They should get ready on merits. Mere interim order will not be extended. You get ready on merits. If you are ready, you will file a memo. Otherwise, you withdraw it. Yes, you should argue the matter on merits. Yes. File.
Next week. Sir. Any adjournment? List 2, page 7, serial number 59. List 1, page 1. Non-compliance of office objection for first time.
My lords, list 3, serial number 12. Kindly one short accommodation may be granted, my lords.
List 3.
Serial number 12.
So for the petitioner, please for time.
Obliged, my
Number
lords.
18, my lord, 1 week. 18, 1
Which
week.
list, ma'am?
Please, Bella.
Which list?
First list. Kindly wait, madam. Wait. Orders.
Bartin. Order sigide, Bartin.
Non-compliance for first time, serial number 1, Sharat Kumar Shetty.
Representation. Next.
2, Sushant Venkatesh Pai.
Appearing for the appellant, your lordship.
Yes.
Seek a short accommodation.
Yes.
3,
Next.
Sushant Venkatesh.
Appearing for the appellant in this also, my lordship.
Place time. Next.
4, Lohit Ashwabhanekar.
Place time.
5, government advocate.
That's GP place time.
6, Narsim Swamy.
Observe no representation.
7, government advocate.
That's GP place time.
8, Narsim Swamy.
Observe no representation.
9, D.S. Satisha.
Observe no representation.
10, Devarajan.
Absent.
11, Dhananjay Kumar.
Absent.
12, Mariswamy K.
Appearing for the appellant, my lordship. Kindly grant some time, my
Place time.
place for time.
13, Ravindranath K.
2 weeks maybe.
Place time.
2 weeks.
14, Shivakumar.
Observe no representation.
15, Chandrasekhar H.B.
Absent.
16, Archana Murthy.
Absent.
17, Prithviraj.
Absent.
Non-compliance for second time, serial number 18, S.B. Lakshmi. Please, I prefer the appellant. 1 week.
Place time.
19, Arvind K.V.
My lords, for appellant, my lords, memo of conversion has been filed. The name has to be deleted. Sushal Tiwari's name has to be replaced.
ಏನಾಗಿದೆ ಪರ್ಮಿಟ್ ಮಾಡ್ಬೋದಲ್ಲ ಇವ್ರು ಯಾರು ಹೂ ಇಸ್ ರೆಪ್ರೆಸೆಂಟಿಂಗ್ ದಿ
Sushal
appellant
Tiwari.
has filed a wakala
Yes,
when
I'll have to check, my lords.
then you have to check and make submission.
Please.
Simply you cannot say yes.
He's a panel advocate as well, my lords. We had filed it along with Mr.
Who is he?
Sushal Tiwari. my lords.
So and so. Submits that he has undertaken to represent the appellant and file wakala. Office is directed to show his name in the cause list and delete the name of so and so. Next part, when counsel for the appellant filed a memo seeking permission to convert the criminal appeal into criminal revision petition. Memo is accepted. Appellant is permitted to convert the criminal appeal into criminal revision petition. For statistical purposes, criminal appeal stands disposed of.
My lords, can I request a similar order in serial number 34, my lords?
Wait for some time.
Please, ma'am.
Next.
Serial number 20, Ravi Kumar Piyar.
Counsel for the appellant. 2 weeks.
Place time.
21, Satish Kumar H.S.
Absent no representation.
22, Kantraju N.K.
Place time. Yes. Next.
23, Baburjang Trishuli.
2 weeks.
Place time.
24, Mohan Chandra P.
Absent.
25, B.B. Patil.
Therefore, the appellant, your lordship.
Place time.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ACB ಪಾರ್ಟಿ ಮಾಡಬೇಕಿತ್ತು ಅಂತ ಹೇಳ್ಕೊಂಡು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿದ್ದಾರೆ. ACB ಆಲ್ರೆಡಿ ಅಬಾಲಿಷ್ ಆಗಿದೆ.
Applicant cause title to be corrected. Same is not valid with order. Yes, what is your submission?
ACB ನ ಪಾರ್ಟಿ ಮಾಡಬೇಕಿತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. ACB ಆಲ್ರೆಡಿ ಅಬಾಲಿಷ್ ಆಗಿತ್ತು ಸರ್.
CCB.
ACB
ACB. ಅದೇ
2022 ನಲ್ಲೇ ಆಲ್ರೆಡಿ ಅಬಾಲಿಷ್ ಆಗಿದೆ.
Yes, you have to correct the provision of law,
Yes, we will comply.
pass over.
Serial number 26, L Sudarshan, non-compliance for third time.
Withdrawing the appeal. Counsel for the appellant filed a memo seeking permission to withdraw the appeal. Based on record, appeal is dismissed as not pressed. Yes.
Serial number 27, Prakash
For
RN.
appellant to lordship, for appellant to lordship, 2 weeks time.
ಅದು
For
finally,
appellant.
counsel prays for time ಅದೆಲ್ಲ full ಹಾಕೋಬೇಕು. Sir, it is posted finally, please comply with the office objections immediately.
Please, sir.
28, Prakash Kini, Rakesh Kini.
For appellant, 1 week.
Finally, next,
29, Vishwanatha.
finally. Pass over.
30, Srinivas K.
ಯಾವುದು 29 finally, no?
Yes, 29.
38,
30, Srinivasa K. Not final.
absent no representation, list finally.
31, Government Advocate.
ಅದು finally, HCGP prays for time. Next,
32, Madhav Swami.
absent finally as Russians.
33, Government Advocate.
Finally,
Non-compliance for fourth time, serial number 34, Sushil Tiwari. Remove for
For the appellant, conversion, memo for conversion.
counsel for the appellant filed a memo seeking permission to convert the criminal appeal into criminal revision petition. Memo is accepted, permitted, are they happy? Other office objections complied. Then counsel for the appellant submits that all other office objections are already complied with. Yes.
Obligement.
For order, serial number 35, R. Rajesh Shetty.
Answered as he is not found in this address. Notice issued to respondent returned answered as not found in the address. Counsel for the appellant is absent, no representation. List down. Next.
36, Samir SN.
Obrena respondent.
Only one respondent.
Counsel for the appellant is absent, no representation. Memo is filed reporting death of respondent on 15/5/2021. Copy of the death certificate is also enclosed. Appeal is dismissed as awaited.
Serial number 37, Sridhara B.E. Jordan, the brother.
As per police report, notice is served on the brother of the respondent. Service is held sufficient, respondent called out absent. List for final hearing. Bandida trial court, bandida. List for final hearing. Next.
Serial number 30, Vetri Madhe Samuel.
As per police report, notice issued to respondent is served on his counsel. Service is held sufficient, called out absent. Next is list for admission. Next.
39, Government Advocate. Not found in the address.
Counsel for the appellant is absent, no representation. Then the HCGP prays for time to verify the correct address and of the respondent and to furnish the same. List out. Next.
40, V. Ramesh. Not found in the address.
Counsel for the appellant is absent, no representation. Notice sent to respondent returned answered as not found in this address. List on.
41, Ian Jagdish.
Appearing for the appellant matters.
Hmm.
In this, the respondent has not been served due to lack of sufficient address. 3 weeks' time may be given.
Prays for time. Counsel for the appellant prays for time. Next.
42, H. Manjunath.
Appear for the appellant, my lords. Kindly reissue them.
Not found in the address.
Not found in the address. Vacated ಅಂತ ಬಂದಿದೆ.
Yes, you have to find out the correct address.
I shall find out. my lord.
Prays for time to furnish correct address.
Great.
List 2, serial number 1, J. Prakash.
Immediate approach for the lower court to the
Hmm.
respondent.
Hmm.
And she was arrested on the Saturday.
Hmm.
Not-
Hmm. Argue the matter. I will hear you and proceed. I will hear you, both of you, and dispose of the appeal.
If I gone through the file, I can give the appeal.
When will you argue?
Yeah.
When will you argue?
Any next week.
Give me the date of your choice. But till then, he will be in custody. That is why you get ready today, address the argument. I will hear both of you.
Appeal, I will argue next week. She may be released.
ಇವೆಲ್ಲ exercise ಬೇಡ, sir.
I will have to- lower court also I have to.
Hmm.
Even my.
What prevented you from appearing before this court? 2013 matter. 11 years the respondent, no. Well, ಹೇಳ್ಬಿಡಿ.
It was shifted the distance to Andhra. Children are in Namabi.
Hmm. Then,
She also not received any notice for this. After knowing that she called my court, I know.
ಏನ್ ಮಾಡ್ಬೇಕು ಇವಾಗ?
But I will reach out. I will any day 6. I will.
ಏನ್ ಮಾಡ್ಬೇಕು?
I will give the copy.
ಹಾ, yes. Then it counsel for the, Huh?
I present not this, I will.
ಏನು, what is your submission, sir?
No, in the court, through the check bones case was.
ಆಯ್ತು, ಅದೆಲ್ಲ on facts of the case.
My, please not. I
How?
will any day.
How she is to be released? Simply I have to pass an order, release the respondent. There is a procedure to be followed. You must know that.
Not aware of, knowing that it will not appeal.
Counsel for the appellant and respondent pray for time to address their arguments. And the first given, NBW issued against the respondent is reported to have been executed. So and so, or acceptable, so and so. He is personally present before the court and submits that he represents the respondent. Both the learned counsel for the appellant and respondent undertake to address their argument on so and so date over the convenience scale. List on, yes, next,
Date
next. Date ಕೊಡ್ತಾರೆ.
25th,
ಏನು ಹಾಕದೆ ನಮಗೆ.
25th or 28th.
ಯಾವತ್ತಾದ್ರು, any date convenient to both of you.
Wednesday to Friday, sir.
Next.
25th,
Wednesday to Friday.
Wednesday to Friday. 28th.
Yes, next,
Please.
next.
Serial number 2, A Nagarajappa, PD Surana.
Appearing for appellant lordship, kindly for
Yes, who is for the appellant?
I am for the appellant
Ah.
lordship. Kindly seeks a week's time lordship. We have to collect the record.
You do not have the certificate copies,
No,
both of you?
lordship.
What about you, sir?
I have submitted my available records.
Already submitted? What about the other
They have
material?
not received lordship. We will collect it and will.
3rd February 22.
Learned counsel for the respondent submits that he has produced some of the certificate copies of the, yes, sir, he has produced the available records before this court. The counsel for the appellant prays for time to collect the other documents and to place it on record. In the meantime, a letter is received from the trial court to take steps from the trial court, informing that the steps are taken for reconstruction of the missing records. A month's time is granted. 8 weeks' time is granted to reconstruct the records and to forward the same. In the meantime, the counsel for the appellant to produce the certificate copies of the documents available with the appellant. Yes.
Serial number.
Time.
8 weeks.
8 weeks' time is granted. You furnish the certificate copy
Yes,
which are available.
Yes, Lord.
Yes.
Much
next.
of.
Serial number 3, Mohammed Tahir.
Both are ready to compromise.
So and so
Both parties are present.
filed the wakalat for the respondent. What is that you have filed? Wakalat ashta. Why the parties are present?
They are settling lordship, both the disputes.
So what is to be done?
Compromise affidavit lordship.
Huh?
Filing compromise affidavit.
ಅದನ್ನ ಹಾಕ್ಬೇಕಲ್ವಾ?
ಇಲ್ಲ ಆಗ್ತಿದೆ.
Then present ಅಂತ ನಿಂತ್ಕೊಂಡ್ರೆ
Yes, I will notarize and file it lordship.
pass over.
Thank you. Much obliged.
Hearing on IA, serial number 4, dear Rashekharappa. Office objection is there now. On IA 2 of 24.
Office objections on IA. Bring the legal heirs of deceased appellant. Who filed?
Appear for the respondent, my lord.
Appellant Rashekharappa. Pass over.
My lords, if a date may be fixed for hearing.
Let him come, his application. Yes,
Serial number 5, GS Srikante Gowda, Syed Kamaruddin.
Your Lordship, on the GPA order for the respondent,
Hmm.
I have filed an NOC of my previous legal counsel.
Hmm.
Filed a memo.
Hmm.
I will be seeking permission, it's for abatement.
you are a party in person.
Not yet, Your Lordship, I haven't yet filed an application,
have
but
to
I filed
file
the
before the
NOC of my legal
committee.
counsel.
Pass over, comes. Pass over the matter.
Serial number 6, Siddharth B. Muchandi. IA for review.
Appearing for the appellant's your case, your lordship. No instructions from the legal representatives to argue the matter, so kindly permit me to retire from the case.
Counsel for the appellant submits that there is no instructions from the legal representatives of the deceased appellant. And therefore, permission to seeks permission to retire from the case. The appeal is of the year 2021. Appeal is, appellant is already reported to have died. Hence, the appeal is abated. Appeal abates. Appeal is dismissed as abated. Next.
Serial
Next.
number 7, Kiran Kumar DK.
I'm appealing for appellant in this case. In this case, we have one submission. This case may be called along with criminal appeal 99 for 2022
is allowed
because
leave is granted. Counsel for the appellant submits that the appeal is connected with
criminal appeal 99 bar 2022.
22. Office is directed to list both the cases together. Yes, next.
8, Srikant B.
So list for next stage. Third, learned counsel for the appellant, IA 1 of 2022 allowed, leave is granted, list for next.
9, N. Isdor Prakash.
Third, learned counsel, IA 2 of 2022 allowed, leave is granted,
10,
list for it.
GB Shivakumar. 761 days.
Counsel for the appellant is absent, no representation. IA 2 of 2022 is filed seeking condonation of delay of 761 days in preferring the appeal. Since there is inordinate delay in preferring the appeal, the same is ordered to be heard along with the merits of the case. List for. List the appeal for so and so along with IA 1 and 2 of 2022. Next.
11, Raju CN.
Third, learned counsel for the appellant, IA 1 of 22, leave is granted. Next.
12, Mohammad Asifullah.
Absent, no representation, perused, IA 1 and 2022 allowed, leave is granted. Next.
13, Vijay Kumar SC.
Waiting for appellant.
Third, IA allowed.
There is a 138 proceeding.
Yes, IA is allowed, leave is granted.
14,
Next.
GB Shivakumar. 761.
We do same on merits, along with merits.
Jeevan J. Neralgi.
We
1002.
do same. Absent of us. Next.
16, Ramesha MN.
Third, IA allowed. IA is
17,
allowed. Next.
Kamaraju.
Counsel for the appellant is absent, no representation. IA 1 of 2022 special leave granted. IA 2 of 2022 seeking permission to produce additional documents. Same is ordered to be heard along with the merits of the case. Yes. Next.
18, E. Vishweshwaraya.
Appear for the appellant.
Third, learned counsel for the appellant, IA is allowed, leave is granted. Yes.
19,
Date, my lord, it is 2021 appeal.
Further.
19, R.B. Deshpande.
Appellant, IA is allowed, list for admission.
20, Ashok Kumar Shetty.
IA is allowed, list for admission, absent.
21, Akash Kumar Gowda.
Third, IA 1 is allowed, leave is granted, list for admission.
22, Jayanti S.
ಅದು absent or representation, leaving granted.
23,
Records ಬಂದಿಲ್ಲ ಅಂದ್ರೆ
Rashid
ಅದನ್ನ
Khan.
ಮಾಡ್ಕೊಳ್ಳಿ. ಎಲ್ಲದ್ರಲ್ಲೂ. Absent no representation, IA is allowed. Huh?
138, sir.
Yes, heard. IA is allowed. Next.
24, Ashwath Reddy.
Heard. IA is allowed. Yes, next.
25, D. Prabhakar.
Absent no representation, IA allowed. Leave is granted.
26, A. Salmati.
Appear for appellant, my lord. I am not pressing for IA for delay, my lord. There is no delay, my lord.
Seeks permission to withdraw IA two of 2022 as not pressed. Submission is placed on record. IA two of 2022 is disposed of as not pressed. Yes.
Much obliged, my lord.
List for
27.
admission.
S. Shankarappa.
Applying from appellant. 17 days of delay.
Third learned counsel for the appellant on IA one and two of 2022, seeking condemnation of delay of 17 days and the leave of the court to prosecute the appeal for the reasons stated in submission. IA is allowed. IA next to IA three of 2022 is filed seeking permission to produce additional documents. The same is ordered to be heard along with the main matter. Call for trial, court records, list for admission.
28, Shivkumar P.
IA is allowed, leave is granted. Next.
29, Shambhanna BH.
Appellant, my lord. There is delay of 7 days, my lord.
IA one and two allowed. Yes,
30.
admission, both the applications.
Vyasa.
Absent no representation, IA allowed.
31, Prasanna Kumar P.
For the appellant, 138 proceedings. IA number 2, my lord, not pressed.
Not pressed,
Not delay.
dismissed as not pressed. Yes,
Specially, may be, I 138 proceedings.
leave ಎಲ್ಲಿದೆ IA ಇಲ್ಲ.
IA number 1, my lord. IA number 1 is for special leave. IA 2 is for condonation.
ವೆರಿಫೈ ಮಾಡಿ. ಅದು IA ಇದ್ರೆ ಅಲೋ ಮಾಡಿ. Yes.
Please.
32, VG Vijay Kumar Swami.
Absent no representation, IA one and two of 2024 allowed, delayed, condoned, leave granted.
33, P. Vittal Shetty.
Absent, IA allowed, leave granted.
34, Government Advocate.
Third executive on IA one of 2022 for the reason stated so and so, IA is allowed 12 days. Delay of 12 days in preparing the appeal is condoned. List for admission. Next.
35, Suresh Iyer.
Leave, IA is absent no representation, IA allowed, leave is granted. Call for trial court records, list for admission.
36, P. Prasanna Kumar.
I appeal for the appellant, my lord.
Third, IA one of 2022 allowed, leave is granted. Call for trial court records, list for admission.
37, Naveen GS.
Absent no representation, IA one of 2022, one of 2023. Have to allow ಮಾಡಿ for the reasons stated so and so. Delay of
38.
73 days condoned. Next.
38, Jaykumar PP.
Appearing for appellant,
Third, learned
my lord.
counsel for the
Case has
appellant
been
on IA one and two of 2020.
Memo.
That ಬೇಡ. Then counsel for the appellant filed a, what is that? You are withdrawing that.
Yes, sir. Yes, ma'am.
Counsel for the appellant filed a memo seeking permission to withdraw the appeal as the dispute is settled between the parties. Memo is placed on record, appeal is dismissed. Pending the year one and two of 2022 also dismissed.
39, MS Rajendra.
Appellant.
A one of 2022 allowed, leave is granted. Next.
40, Chapparna.
Absent, leave is granted.
41, Sridhara K. 132.
Absent, no representation. Next. Order to be heard along with main matter. List for admission along with IA one and two of 2022. Next.
42, Satish K. 131.
There is delay of 131 days. Why there is delay?
Let's see, legal service authority matter, madam, it's kind,
So legal service andre, you need not have to look into the papers.
it's kindly pass it.
Huh?
Pass it.
Pass over.
43, RP Somshakaraya.
Absent, no representation. IA 1 of 2021 allowed. Next.
44, Nageshes.
For the
Third,
appellant in this
IA
case,
1 of 2022 allowed, list for admission. Next.
45, B Manjunath.
appellant in this case.
Allowed, IA is allowed. Next.
46, Pawan TG.
Absent, no representation. IA is allowed.
47, Srinivasan T.
Yeah, for appellant.
IA allowed, list for admission.
48, Jairaj G.
Appellant.
Third, IA is allowed. Leave is granted.
Notice ಹೋಗಿಲ್ಲ ಅಂತ.
ಅದು admission ಗೆ you make out a ground for admission.
Please.
Yes.
49, BR Manjunath.
Absent, no representation. IA 1 and 2 allowed. Delay 14 days condoned. Leave is granted. Next.
50, Sudhir BS.
Absent, no representation. IA allowed. Next.
51, Prasad.
Absent.
Appellant made. ये one bar specially
Third, learn counsel with the appellant on IA so and so and so. Leave is granted. Condonation, delay condoned, leave is granted.
52, BS Prasad.
Third, IA is allowed. Leave is granted. Admission.
53, N Shivakumar. 144 days.
My lord, I appear for the appellant, my lord.
Yes,
There
there
is
is
a
delay of 144 days.
Please, my lordships. My lordships, they are uneducated and they are financially deprived, my lordships. And also
Maybe.
applied copy. Sorry, my lord.
Why there is
They
delay?
are. Lord, this is the complainant appeal, my lordship.
Maybe,
After,
sir, I am asking you why there is delay of 144 days.
They have financially incapable, my lordships, and also for searching the advocate's hearings, the reason assigned by the appellant hearing.
Can it be
also
accepted?
illeg-
Could you any
Lords.
reason?
ಅಡ್ವೊಕೇಟ್ ನ ಸರ್ಚ್ ಮಾಡೋದಕ್ಕೆ ಮತ್ತೆ ಅದ್ರ ಬಗ್ಗೆ ಲೀಗಲ್ ನಾಲೆಡ್ಜ್ ತಿಳ್ಕೊಳ್ಳೋದಕ್ಕೆ ಸ್ವಲ್ಪ ಲೇಟ್ ಆಯ್ತು ಅಂತ ಅವ್ರಿಗೆ ನಾಲೆಡ್ಜ್ ಬಂದಿರೋದೇ 10-6 ನಲ್ಲಿ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡ್ತಾರೆ.
1 and 2 of 2022. Seeking IA 1 of 22 things, seeking condonation of delay
Special.
of 44 days for the reason stated in so and so. IA are allowed. Delay of 144 days condoned. Leave is granted. All for trial to capacity for admission. Both the applications allowed, list for admission.
Serial number
Yes, sir.
54, H.A. Manjunath. Special number, IA 1 of 20.
Absent, no representation. IA 1 and 2 allowed. Leave is granted. Delay condoned. Next.
55, Baburao M.
First to delay condoned. ಆಮೇಲೆ
55, Baburao M.
representation. IA 1 and 2 of 2022 allowed. Next.
56, Manjunath KS.
Absent, no representation. IA 1 and 2. 1 of 22, 1 of 23 allowed. Next.
57, for further hearing, Venkatesh Sarbatti. AC Manjunath.
Good. Yes, proceed.
Last date of hearing, Albert undertake to file a synopsis, written synopsis.
Yes, you proceed with the matter. Let him come. How do you support the judgment?
The matter of misappropriation of assets, disruption of assets. The trap was conducted on 3/2/1998.
Hmm.
But accused is a storekeeper in Hemavati, Nalapur. And is,
The storekeeper.
yes, bro.
Huh.
At the time of right, my lord. $32 years, 5 months service is rendered.
Yes.
Look, the charge is very much defective is there, madam.
Huh?
The charge is defective.
Why?
But they said, my lord. Page number, ink page number 11, my lord.
Hmm.
I will come to this. There are two charges for framed by before the trial court, my lord.
Hmm.
The charges, my lord, in first charge dated 13th April 2010, my lord. May I read, my lord? That being a public servant, having served the Public Works Department of the state of Karnataka.
2110.
Before that one charges, my lord. 13th April 2010, my lord.
Huh. Why two charges were framed?
The first charges is also defect and second charge is also defect, my lord. There is a correction, my lord, in figures, my lord.
Then?
Then again, the London session judge framed a charge in,
On 14/8/2007.
yes,
14/8 first in the 13th April 2010.
21st October 2011, second charge.
Then finally, which is the charge?
21st October 2011.
October 2011.
Yes, ma'am.
Yes.
Lord, in the charge, my lord.
Yes.
My lordship, kindly pass over the matter, my lordship. 15 FI.
ಬರ್ಲಿಕ್ಕೆ. Yes.
Yes.
Yes, proceed.
Please. Lord, as per the charge, my lord, the total salary income taken 9 lakhs, my lord.
Exact 9 lakh.
Yes, ma'am.
Yes.
And expenditures, my lord, 5,74,965, my lord. The total asset and liabilities, my lord, 15,77,193, my lord. Total 24,77,193, my lord. Sorry.
Yes.
ಅವಸರವಾಗಿಲ್ಲ ಹೇಳಿದೆ ಬರ್ಲಿಕ್ಕೆ
ಏನ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಸಿನಾಪ್ಸಿಸ್ ಅಂತ ಹೇಳಿದ್ದೆ.
ಅದೇ ಸಿನಾಪ್ಸಿಸ್ ಇದೆ, ಪ್ರಿಂಟ್ ಆಗಿ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. ಕೈಲಿ ಬಿಫೋರ್ 12 o'clock ಆಗಲಿ.
ಅದು ಆಗೋದೇ ಇಲ್ಲ, ಅದು
ಆಗಿದೆ ರೆಡಿ ಆಗಿದೆ.
ಪಾಸ್ ಓವರ್ ಇಲ್ಲದೆ ಮಾತೇ ಇಲ್ಲ.
ಈ ತರ ರೆಡಿ ಆಗಿದೆ. ಇಟ್ ಈಸ್ ರೆಡಿ ವಿತ್ ಕಂಪ್ಲೀಟ್ ಪ್ರಿಂಟ್ ಔಟ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ದಿ ಐ ಶುಡ್ ನಾಟ್ ಸೇ ಫಸ್ಟ್ ರೌಂಡ್ ಬಟ್
ಅದೆಲ್ಲ ಅಲ್ಲಿಗೆ ಆಯ್ತು, ಇಲ್ಲಿ ಇರೋದಿಲ್ಲ.
ಅದೇ ತಾವು ಫಸ್ಟ್ ಇದು ಮುಗಿಸಿದ ತಕ್ಷಣ ಅಥವಾ ನಾನು ಕಮೆಂಟ್ಸ್ ಮಾಡ್ತೀನಿ, ಅಷ್ಟ್ರಲ್ಲಿ ಬರುತ್ತೆ. ಗ್ರೇಟ್.
Number 58, K. Jagdish, M. Sridhar Chakravarti.
Here for respondent, on the last occasion, this honorable court directed me to reduce the ಕೊಡಿ.
Yes. Yes.
Paragraph 9 we looked into in the judgment. No? Our
Yes.
defense is that, my lord, the one Mr. Lakshmi Narayana induced me to grant the loan, and thereafter he has planted two, Rajshekhar and Murugesh, and both the cases I have been acquitted, even including this Lakshmi Narayan case. Paragraph 9, may I read, my lord? It is a specific defense of the accused as can be made out from the cross-examination of PW1 that the demand notice exhibit P5 is not duly served to the accused. Secondly, complainant has no source of income to pay 8 lakhs. And lastly, complainant has not produced the agreement of sale to prove the existence of agreement of sale between the complainant and the accused for the sale of the house which belongs to the accused. The complainant has also not produced mortgage deeds of which the complainant claims that he is mobilized 4 lakhs each.
What is the
amount into-
contention of the complainant in that case?
Pardon, my lord?
What was the contention of the complainant?
The complainant contention is that, my lord, they entered into a sale agreement and thereafter a cancellation was executed. In fact, my lord, in the chief and the cross also, he has admitted I have the sale agreement, which was not produced before this court, before the trial court. And thereafter, my lord, the complainant urged that he mobilized the funds through the leased property of two properties worth 4 lakhs rupees.
In
And
this case, what is the number of the check?
my lord, that number of the check is different, my lord, but that is observed in the trial court judgment. May I produce what are the nexus between the Lakshmi Narayana, Murugesh and the Rajshekhar has been, my lord, highlighted in the trial court judgment, my lord. May I be permitted to furnish it, my lord?
Yes,
May I produce this judgment, my lord?
judgment in
Trial court judgment where the nexus between the Lakshmi Narayana, Murugesh and Rajshekhar, who is the present complainant before this.
what is the nexus?
My lord, all are known to each other. And my lord, although they denied, my lord, every hearing, my lord, all the three cases were posted on the same dates. And my lord, the Lakshmi Narayana was instrumental in planting Murugesh and Rajshekhar. And my lord, all the transactions has taken place in the year 2011 and 12 itself, my lord. And all the three cases have been acquitted, my lord, on the ground that all the three people are doing ordinary jobs who cannot advance the loan of rupees either 5 lakhs, 8 lakhs, or even 5 lakhs.
No, why you handed over the blank check to Lakshmi Narayana?
My lord, he had assured me of getting the loan for my construction of the house. In 2011, my lord, I was in need of finances for building my house. So, my lord, he is a very known relative to me. Thereafter, my lord, I have approached the KSRTC and BMTC Cooperative Society for the granting of loan, which was sanctioned. Unfortunately, I have not produced that, my lord, but that is observed in the trial court judgment.
Whether such a defense was taken in that case?
Which case, my lord? Yes, my lord.
Filed by Lakshmi Narayana?
Yes.
Where it is stated in the judgment?
My lord, it has not been narrated here, my lord, in this court judgment, my lord, but in the trial court judgment, it is there.
Good.
Please, my lord. Paragraph 10, my lord. Page 10, paragraph.
Yes.
May I read, my lord?
Yes.
During the course of defense evidence, the accused herself examined as DW1, and in her examination in chief, she has deposed that the complainant is a relative from the side of her husband. She deposed that she had never executed agreement of sale in favor of the complainant to sell any immovable property, nor she had borrowed any amount from him as advance, and she had not given check in question to the complainant for any purpose. Further, the allegation of the complainant that she had cancelled the agreement, sale agreement, and for the return of the advance sale consideration, she had issued 2 checks. She deposed that in the year 2011, she was trying to raise the loan for the purpose of construction of a residential house. And at that time, the complainant, being her own relative, was visited to the house of the accused often and often. And he has taken 5 signed blank checks and signed 1 stamp paper, assured that he will arrange loan from somebody else. But the complainant has failed to arrange the same as assured by him. Then she had demanded for return of signed blank checks and signed stamp paper, but he failed to return the same. Further, she has deposed that she had managed to get the loan from different cooperative societies of BMTC, KSRTC, and City Cooperative Society, and got registration of her construction of her house. She deposed that she has not received the legal notice issued by the complainant with respect to the check in question, and the complainant had got managed to file different cases through different people as against her, misusing her 5 checks apart from the case in hand.
How many cases were registered against you?
Totally the 3 cases, my lord.
Which are they? CC number 7909?
CC number 7909,
999.
CC number 1695.
1695.
ನಿಮಿಷ ಇರ್ತೀರಾ? Sorry, my lord. First is, my lord, CC 7909 of 2012.
Yes.
Second one is, my lord, one 7990
Of,
2012.
that is also by Lakshmi Narayana.
No, my lord, one Mr. Murugesh. That was convicted in the trial court, my lord, but the first appellate court acquitted me on the same ground that the nexus between these 2 people and the source of funds is not available with the complainant to advance the loan. This case filed by Rajshekhar has been acquitted by the trial court on.
Which is the third one?
Third one is this only, my lord.
CC number?
6886.
CC number 16816 of 2012.
In 17996, what was your defense? That was the complaint filed by Murugesh.
Please, my lord. May I produce the judgment?
ಏನು ಹೇಳಿ ನಾನು ಕೊಡಿ 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 ಕೊಡಿ.
Paragraph 10, my lord. Page 7.
Yes.
During the course of the defense evidence, the accused held examined as DW1. In the examination in chief, she had deposed that complainant is a stranger to her, and she has not at all borrowed the loan in question from a complainant, and she had not at all issued exhibit P1 for the discharge of loan in question in the year 2011. She deposed that in the year 2011, she was intended to raise loan for the purpose of construction of her house property, and one Lakshmi Narayana, who was the complainant in CC number 7909 of 2012, was her close relative through her husband, and the said Lakshmi Narayana totally taken 5 checks and e-stamp paper in the year 2011 by assuring that he will arrange the loan from the financial institution. But he failed to arrange the loan as assured by him, and he filed complaint against her bearing CC 7909. She deposed that she had managed to get the loan from different cooperative societies of VMTC, KSRTC, and City Cooperative Society and got the constructed of the house. I have taken the same similar defense in all cases, Mala. Other than Lakshmi Narayana, Murugesh and Rajshekhar are strangers, my lord. I have no nexus with them at all.
Yes.
Lord, for a moment, may kindly turn to complaint paragraph 2. The
Yes, what do you
advancement
say,
of
sir?
loan itself is not done.
I'm
Yes, sir.
submission. Cross examination of DW1, page number 5 ನೋಡಿ. Dated 16/4/2006.
Yes.
16th.
16/4/2006 says.
ಇದರಲ್ಲಿ ಲಾಸ್ಟ್ ಫೇರ್ ಅಲ್ಲಿ ನನ್ನ ಪರವಾಗಿ ಸದರಿ ಲಕ್ಷ್ಮೀನಾರಾಯಣ ಅವರು ಬಾಂಡ್ ಪೇಪರ್ ಅನ್ನು ತೆಗೆದುಕೊಂಡು ಬರುತ್ತೇನೆ ಎಂದು ಹೇಳಿದೆ. ಅದರಂತೆ ನಾನು ಹಣ ಕೊಟ್ಟೆ. ಋಣದಾರ ಪತ್ರ PS ದೀಪಾ ಎನ್ನುವರ ಹೆಸರಿನಲ್ಲಿ 26/9/2011 ಹಿರಿಯ ಉಪನ್ಯಾಸಕ ಯಲಹಂಕ ಬೆಂಗಳೂರು ಅವರ ಕಚೇರಿಯಿಂದ ಪಡೆದುಕೊಂಡಂತ ದಾಖಲೆ ಸದರಿ ಸಾಕ್ಷಿಗೆ ತೋರಿಸಿದಾಗ ಸದರಿ ದಾಖಲೆ ನಾನು ಪಡೆದುಕೊಂಡಿರುವುದಿಲ್ಲ ಎಂದು ನುಡಿದಿದ್ದರಿಂದ ಅದನ್ನು ಗುರುತಿಸಲಾಗಲಿಲ್ಲ. ಸದರಿ ಫಿರ್ಯಾದಿ ನನಗೆ 5 ಲಕ್ಷ ರೂಗಳು ಸಾಲದ ಹಣವನ್ನು ನೀಪ 16 ಮತ್ತು ಮೀನಾಕ್ಷಿ ಫಿರ್ಯಾದಿ ತಾಯಿಗೆ ನನ್ನ ಸಹಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದರಿಂದ ಪ್ರಸ್ತುತ ಫಿರ್ಯಾದಿ ನನಗೆ 5 ಲಕ್ಷ ರೂಗಳನ್ನು ಸಾಲದ ಹಣ ಕೊಟ್ಟಿರುತ್ತಾರೆ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ.
ಏನು, what is that suggestion?
ಅಲ್ಲ, ಇವ್ರ ತಾಯಿನಲ್ಲೇ ದುಡ್ಡು ತಗೊಂಡ್ರು ಪತ್ರ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತೇಳಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅದು ನಾನು ಪಡ್ಕೊಂಡಿಲ್ಲ ಅಂತ
So
ಹೇಳ್ತಾರೆ.
according to you, the loan was granted to her mother.
ಅಲ್ಲ, ಇವರೇ ಕೊಟ್ಟಿರೋದು.
Mother ಯಾಕೆ ಬಂದ್ರು ಮತ್ತಲ್ಲಿ?
ಅಲ್ಲ, ಮದರ್ ಬಹಳ ಪರಿಚಯ ಇದ್ರು, ಕ್ಲೋಸ್ ಆಗಿದ್ರು ಅಂತ ಅವ್ರ ಕೈಗೆ ನಾನು ಕೊಟ್ಟೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಪೇಪರ್ ಸ್ಟಾಂಪ್ ಪೇಪರ್.
It demolishes your contention. Throughout your contention was that
ಅಲ್ಲ,
you lent the amount to the accused.
ಅಲ್ಲ, ಸ್ಟಾಂಪ್ ಪೇಪರ್ ಕೊಟ್ಟಿದ್ದು.
Now suggestion is that you paid the amount to her mother. Will it not, is it not fatal to your case? Totally different contention.
And there are further several cases are pending against Deepa. We have stated the complete details of the case also.
Yes, even according to him, 3 cases were filed.
ಅಲ್ಲ, ಇದರಲ್ಲೂ ಇದೆ ಸರ್. ಇನ್ನ ನಂಬರ್ 11715 of 2015 CC. ಕೆ ಸುಬ್ರಹ್ಮಣ್ಯ ಅವರು ಸಹ ನನ್ನ ಮೇಲೆ ಚೆಕ್ ಬೌನ್ಸ್ ಪ್ರಕರಣ ದಾಖಲಿಸ್ತಾರೆ ಅನ್ನೋದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಇದಿದೆ, ಕೇಸ್ ಇದೆ ಇದು. ದಿಸ್ ಕೇಸ್ ಇಸ್ ಆಲ್ಸೋ ಪೆಂಡಿಂಗ್. ಅದೇ ರೀತಿ ಒಬ್ಬಳು ಲೀಲಾವತಿ ಅನ್ನುವ ಮಹಿಳೆ ಮೇಲೆ ನನ್ನ ಮೇಲೆ CC 15,357/15 ಪ್ರಸ್ತುತ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ವಿಚಾರಣಾ ಹಂತದಲ್ಲಿ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ.
She has denied it.
ಅಲ್ಲ, ದಿಸ್ ಕೇಸಸ್ ಆರ್ ಪೆಂಡಿಂಗ್.
Pending ಅಂದ್ರೆ
No, it has been transferred to small causes court. ಅದೇನಾಗಿದೆ ಅಂತ ನೋಡ್ಬೇಕಾಗಿತ್ತು ಅದನ್ನ.
ಅದೇ ಅದ್ರ ಬಗ್ಗೆ ಏನು no materials are placed before it.
And regarding she has given check to the Lakshmi and there is no complaint to the police. ಯಾವ ಇದರಲ್ಲೂ ಹೇಳಿಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ. ಆ ಕೇಸಲ್ಲಿ ನಾನು ಕೊಟ್ಟಿದ್ದೆ ಮಾಡಿದ್ದೆ ಅಂತ.
Now you have
And
to,
there was no reply.
now you have to prove the lending of the amount.
After receiving the notice, she has not given reply.
Now you have to prove the lending of the amount. Your capacity to lend and lending of the amount.
ಅಲ್ಲ, ನನ್ನ ಬ್ಯಾಂಕ್ ಎಕ್ಸಿಬಿಟ್ P16 ಅಲ್ಲಿ ಬಂದಿದೆ ಸಮ್ 8 lakhs.
Your brother.
ಅಲ್ಲ, ಬ್ರದರ್ ಕಡೆಯಿಂದ ನನ್ ಬಂದಿತ್ತು. ನಾನು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದೆ.
When?
ಅಲ್ಲ,
Why you have not produced your bank statement?
ಮಾರ್ಕ್ ಆಗಿದೆ ಸರ್. ನನ್ನ
Your bank statement.
ಅಲ್ಲ, ನಂದೇನಂತ ಇದಿರ್ಲಿಲ್ಲ, ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
Sir, you have to prove your lending capacity, not the lending capacity of your
ಅಲ್ಲ,
brother.
ಆ ಅಮೌಂಟ್ ನಿಮ್ ಕಡೆ ಬಂದಿದೆ ಸರ್. ಮೈ ಬ್ರದರ್ ಫ್ರಮ್
Why,
ಸರ್ ಐ
sir? Why
ರಿಸೀವ್ಡ್.
See, you could produce the bank statement of your brother, your father, your mother, but not yours. Why? Adverse inference will have to be drawn. Deliberately you suppress the document. Because it was not favorable to you. That is the conclusion to which the court can arrive at. When you withhold the document, that is the adverse inference that could be drawn.
ಅಲ್ಲ, how I have mobilized the funds ಅನ್ನೋದಕ್ಕೆ I have produced the documents. I had money.
What is the reason why you have not produced your bank statement? Simply you could have produced the passbook saying that I was having sufficient amount on that day. At least during that period. ಇಲ್ಲ, ಏನೂ ಇಲ್ಲ.
His contention is that, my lord, he obtained a loan from Tata Capital.
Yes. 15 lakhs.
15 lakhs. Even that loan
There is no
transaction is not produced. In fact, my lord, paragraph.
So all these contentions will prove one thing, that you are not having financial capacity. You got the amount from your brother, from your father, availed the loan from Tata Capital, and lent the amount to him without any document. Can it be believed? Very weak case. ಏನಿಲ್ಲ ತಗೊಳ್ಳಿ.
As per a recent Supreme Court judgment.
ಎಲ್ಲ judgments ಇದಾವೆ sir, that it to be
Ideal
applied to the facts of the case.
capacity is not a criteria, Sumadran. When he has admitted, check and check.
The
content.
accused, when the accused fails to rebut the presumption. Here the accused has stepped into the witness box, deposed about issuing blank checks, 5 blank checks to the, who is he, Lakshmi Narayan. Same contention, same defense was taken in all the 3 cases.
ಮತ್ತೆ ಇದ್ರಲ್ಲಿ ಬಂದಿಲ್ಲ. ಈಗ ಲಕ್ಷ್ಮಣ
In both those cases, the defense of the accused was accepted by the court
ಅಲ್ಲ
and he is acquitted.
ಈ ಅಪೀಲ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ದಟ್ ಅಗ್ರಿಮೆಂಟ್ ಇಸ್ ನಾಟ್ ಪ್ರೂವ್ಡ್ ಅಂತ ಅಗ್ರಿಮೆಂಟ್ ಇದೆ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್
But please understand the sequence of events. The defense is Lakshmi Narayana is there. He collected 5 blank checks. The said defense was taken consistently in all the 3 cases. It is not a stray defense taken in this case. That is why I asked him to produce that. If that was not the defense, I would not have believed the defense. Yes, since the defense was taken, similar defense was taken in all the 3 cases. The burden on the accused is, gets discharged. Burden shifts on the complainant. But you have not proved the lending of the amount nor your capacity to lend. There you fail. Ashte.
With great respect, my lord, in paragraph 2 of the complaint, he states that in November I approached for the loan.
Thereafter February.
No, my lord, here it says he will take some more time to obtain the loan and grant the funds sought for. But in February itself, he states, I have to obtain the Tata Capital loan to give it to the accused. But here in the complaint, he says 2011, I will obtain a loan and give. This is the fatal ground, my lord.
Review the material, point for consideration. My answer to the above point in the negative for the following reasons. The complainant has filed the private complaint, PCR 5963 of 2012. See the against the accused, specifically contending that the accused had approached him during November 2011, seeking hand loan of rupees 5 lakh for the purpose of construction of a building undertaken by her father. She also stated that she had already applied for blank loan, but sanctioning the loan will take some time, and during that period, she wanted financial assistance. Accordingly, the accused had lent an amount of rupees 5 lakh. Date of lending is not stated in the complaint. However, it is stated that the accused has issued 2 checks for rupees 2,50,000 each on 15/11/2011 and 20/11/2011 respectively towards discharge of the loan. So, when the checks were presented for encashment, both the checks were dishonored as the payment stopped by the drawer. The notice sent to the accused returned answered, nor the acknowledgement has been returned. And as per the postal endorsement, however, it is contended that the speed post sent to the address of the accused is served on her. In spite of that, she has not repaid nor replied. to the legal notice and thereby committed the offence punishable under section 138. The accused has pleaded not guilty after appearing before the trial court. The complainant examined himself as PW1. The tenor of cross-examination to PW1 discloses that the accused has taken defense that she had approached Narayan, her relative, for financial assistance, and he had obtained 5 blank checks with her signatures, promising to lend the amount, but later failed to lend any amount. The further defense that said Lakshmi Narayan managed to project one mortgage and the present complainant by handing over the blank checks belonging to the accused. And it is stated that Lakshmi Narayana, Murugesh, and the present complainant have filed 3 different cases against it. Therefore, it is the defense of the accused that the complainant and Murugesh were strangers to her, and she never approached them, nor obtained any loan. And therefore, the offense under section 438 is not made out. The complainant has denied these suggestions put to him, but contended that he had lent the amount to the accused. During cross-examination, he gives a go back to his contention taken in the complaint and contends he had lent the amount during February 2011 by raising the loan of rupees 15 lakh from Tata Capital, out of which rupees 5 lakh was paid to the accused. During cross-examination, PW1 further states that he had availed the loan of rupees 5 lakh each from his brother and father, respectively, and 15 lakhs from Tata Capital. But no document worth mentioning is produced to prove this is. However, when the accused admits the check exhibit P1 and 2 belongs to her bank account and it bears her signature, the presumption under section 138, 139 and 118 of NIA would arise. The initial burden on the complainant gets discharged, and it is for the accused to rebut the presumption by probabilizing her defense. In order to probabilize her defense, the accused has cross-examined the complainant PW1. ಅದು ಮೇಲೆ ಹೇಳಿದ್ನಲ್ಲ ಫೆಬ್ರವರಿ ಅದೆಲ್ಲ ಪಾರ ಫುಲ್ ಇಲ್ಲಿಗೆ ಹಾಕ್ಕೊಡಿ. Further, the accused has stepped into the witness box to depose as DW1, even though the witness was cross-examined at length. Nothing has been elicited from her. Strangely, it is suggested to DW1 by the learned counsel for the complaint that the loan amount was paid to the mother of the accused. This suggestion put to DW1 is fatal to the case of the complainant. It demolishes his contention that he had lent the amount to the accused. Then the counsel for the respondent has produced the judgment in CC 7909 of 2012, dated 4th November 2017, on the file of the learned 12th additional Chief Metropolitan Magistrate Bengaluru, which is a case filed by Lakshmi Narayanappa against the accused, alleging commission of the offence 138 of NI. The accused has taken the defense that she had issued 5 blank checks to the complainant. The same were not returned to her, and later she obtained loan from BMTC and KSRTC societies, etc. However, the trial court convicted the accused. Then counsel produced the criminal revision petition number 1430 of 2018, referred by the accused hearing before this court, which was came to be allowed with a judgment dated 21st November 2023, allowing the revision petition and setting aside the judgment of conviction passed in CC 7909 of 2012 and criminal appeal number 1695 of 2017 on the file of 40th additional City Civil and Sessions Judge Bengaluru. The coordinate bench of this court accepted the defense taken by the accused that she had issued blank checks with her signature to the complainant and later misused the same, even though he had not lent any amount. Similarly, learned counsel for the respondent produced copy of the judgment dated 3rd March 2018, passed in CC number 17990 of 2012, filed by one Murugesh, referred to above, against the accused, contending that he had also lent ₹2 lakh to the accused during April 2012, but the same was not repaid. On the other hand, a check was issued which was came to be dishonored, and thereby accused has committed the offence under section 138 of NI. The accused was convicted in the said case. In this case also acquitted? In which case? Huh? No, then CC 17990, she is convicted.
She was convicted in trial court, but first of it, she was denied.
ಎಲ್ಲಿದೆ ಅದು judgment? ಇದೆಯಾ? He has also produced the judgment dated, passed in criminal appeal number. of 2018 on the file of 40th additional City Civil and Sessions Judge Bengaluru, CCH-61. Wherein the appeal was allowed and the impugned judgment of conviction passed in CC number 17990 of 2012 was set aside. Accordingly, the accused was acquitted. The judgments in these cases disclose that the accused have taken similar defense in all the three cases. And in two other cases, she is already acquitted. That means to say, the courts have accepted the defense taken by the accused to acquit the accused. Next paragraph. It is pertinent to note that the accused has not only cross-examined PW1, but stepped into the witness box and deposed as DW1 in support of our defense. Even though the learned counsel for the respondent produced the judgments in the criminal case, in the criminal appeal, and the criminal revision petition as referred to above, they are all the subsequent documents, and they were never disputed by the learned counsel for the complainant, appellant. If those documents are taken into consideration, in the light of the defense taken by the accused in the present case, I am satisfied that the accused is successful in probabilizing her defense. Moreover, the checks in question were not dishonored as there was insufficient fund in the account of the accused. But on the other hand, the checks were dishonored as payment stopped. Prima facie, the accused must have directed her banker to stop payment of the checks, which according to her taken by Lakshmi Narayana and misused the same. All these facts and circumstances lead to a situation where it is to be held that the accused is successful in probabilizing her defense. Next part. Once the accused is successful in probabilizing her defense, the burden again shifts on the complainant to prove his capacity to lend and also to prove actual lending of the amount. If the evidence of PW1 is taken into consideration, he was having meager income of rupees 20,000 per month by running a workshop. Out of the major amount was being paid by him as monthly installment, and what was available with him was hardly rupees 500 or 600 per month. Even according to the complainant, he was not having sufficient fund with him for the purpose of lending the amount, huge amount of rupees 5 lakh to the accused. He has produced the bank statements of brother and father to contend that he had availed the loan from them. According to him, he availed rupees 15 lakhs from Tata Capital. And from out of all these funds, he could lend rupees 5 lakh to the accused. But strangely, the complainant has never produced either the passbook or the bank statement pertaining to it to show his lending capacity. There was absolutely no reason as to why the complainant had borrowed the amount either from his brother, father, or from the bank and lent the amount to the accused. Therefore, it is to be held that the complainant is not successful either in proving his capacity to lend or to prove actual lending of the account. The complainant is not sure as to when he lent the amount, whether it was during February 2011 or November 2011, as there is inconsistency in the stand taken by the company. Under such circumstances, the benefit of doubt will inure to the accused and she is entitled for acquittal. I have gone through the impugned judgment of conviction passed by the trial court. It has proceeded to convict the accused solely on the basis of presumption under section 139 of an act, ignoring the inconsistency in the case made out by the complainant, and also the defense taken by the accused. Under such circumstances, I am of the opinion that the impugned judgment ಆಗಲ್ಲ, ತಪ್ಪಾಯ್ತು. ಮೇಲೆ ಒಂದು I proceeded to acquit the accused. ಅಲ್ಲ, ಹೋಗ್ಬೇಡ. Acquitted the accused on proper appreciation of the materials on record. I do not find any reason to interfere with this. Hence, I answer the above point in the negative and proceed to prosecute. Appeal is dismissed. Appeal is dismissed.
For final hearing, serial number 59, HC Kavita, Abubakar Shafiq.
The appellant, your lordship, I seek a passover in this matter, lordship. Proxy counsel.
Every day ಇದೆ submission, pass over.
ಇಲ್ಲ.
ಒಂದಿನನು ಮಾರ್ನಿಂಗ್ ಬಂದ್ ಕೂಡಲೇ ಆರ್ಗ್ಯೂ ಮಾಡುವಂತ ಇದೇ ಇಲ್ವಾ?
The first time I'm appearing in this matter.
ಕೊಡಿ ಆರ್ಡರ್ ಶೀಟ್. ಅದಕ್ಕೆ ಪಾಸ್ ಓವರ್ ಇದು ಮಧ್ಯಾಹ್ನದವರೆಗೆ, ಆಮೇಲೆ ಹೋಗುತ್ತೆ ಇದು. Pass over.
Petition, serial number 60, Shant Kumar KC, Vijay Shekhar Gowda.
It may be granted, my lord. While has taken the party, my lord. Party has taken the file. Chennai.
ಆಯ್ತು, record your submission and dispose of.
ಅಲ್ಲ, next.
ಅದ್ರಲ್ಲಿ ಏನ್ ಬೇಡ, ಪಾರ್ಟಿ
ಫೈಲ್ ತರ್ಸ್ಕೊಂಡು I will argue that matter.
ಫೈಲ್ ಇಲ್ದೇ ಇದ್ಮೇಲೆ ಮತ್ತೇನ್ ಮಾಡಿ? ಫೈಲ್ ವಾಪಸ್ ಕೊಟ್ಮೇಲೆ ವಾಟ್ ಈಸ್ ಯುವರ್ ಕೆಪಾಸಿಟಿ?
ಸುಮ್ಮನೆ ಏನು ಸಪ್ಲಿಮೆಂಟ್ is going on, therefore I will.
Counsel for the appellant, please for time. The appeal is of the year 2013.
Monday,
7 years have already lapsed. I do not find any reason to adjourn the matter. When the counsel for the appellant undertakes to address the argument on the next date of hearing without fail, submission is placed on record. List finally as a last chance. Finally as a last chance. Next.
61, Government Advocate T.A. Karambaiya.
Please, my lords. Appearing for the learned advocate for the respondent, my lords, with permission.
Yes.
The accused, case of acquittal. My lord, well reasoned judgment of acquittal by the.
1 minute.
Please.
ಯಾರಿಗೆ ಇದು?
I am for the
Appeal
respondent.
by the government ಅಲ್ಲ.
Please.
I am representing the accused.
No, appeal by the government.
How? By the government, my lords.
Now she is confused whether she is the appellant or respondent.
Now I appear for the learned advocate for the respondent, my lords.
Wait for some time.
Please.
One.
The rule 130 read with number 4. Rule 144 read with rule 165 of the Karnataka Code. Diversion. The sentence 6 months imprisonment for
1 minute. How they are acquitted? Yes. What is the contention of the prosecution?
My lord, the reasons for the acquittal in the appeal, my lord.
Now, first tell me what is your contention?
My lord, my submission is that, my lord, all the prosecution witnesses have supported the case of the
Now,
prosecution.
tell me the facts of the case.
Yes, my
What is the allegation against?
Yes,
the
my lord.
witness?
On 22/12/2006, my lord, in the early morning, my lord, near Ponnampete Old Government Depot, my lord, the accused were transporting 5 black wood logs in the Mahindra Jeep, my lord. My lord, while checking of the vehicles, my lord, they were asked to stop the vehicle, my lord, but they didn't stop.
Yes.
After that, my lord, they were apprehended. And my lord, accused number 1 and 2 were arrested, my lord. Accused number 1 and 2 were apprehended, my lord, and the blackwood, 5 blackwood logs were found in the jeep, my lord. And they,
Number 1 and 2 were apprehended.
yes, my lord.
Hmm.
And 5 blackwood logs were found in the jeep, my lord.
Yes.
And when they were asked to show the permit to transport the forest produce, my lord, they did not produce any permit to transport it, my lord.
Yes.
Hence, a case was registered against them, my lord. And after completing the investigation, my lord, charge sheet was filed, my lord.
In all, how many accused? 3.
3 accused, my lord.
A3 was acquitted by the trial court.
No, my lord, only 2 accused. My lord.
Yes.
Only 2 accused, my lord.
Like A3 was acquitted by the trial court, correct? A3 was acquitted in the trial court because he was a trial court.
He ran away from the spot.
Oh,
No, accused number 3 ಅಲ್ಲಿ ಇದಾನೆ.
oh, he was acquitted, my lords. 1 and 2 were convicted by the trial court. Appeal was filed. With the convicted accused 1 and 2.
Yes.
My lord, the prosecution has examined 6 witnesses, my lord.
7 ಅಲ್ಲ.
6.
PW is 1 to 7.
7 witnesses, my lord.
Yes. Who is PW1?
PW1 is the forester, my lord.
Who waylaid the jeep?
Yes, my lord. And PW2 is the, my lord, he was a daily wage worker in the forest department. He's the merger witness, my lord.
Yes.
PW2 is the deputy range officer, my lord.
PW3.
PW3, my lord.
Ah.
And PW4 is the range officer, my lord.
What they speak?
Sorry, my lord.
What they speak?
They speak about the registration of the FIR.
Both.
Yes, and also raiding, my lord.
No, they were in the raiding party.
Yes, my lord.
Then
PW5 is the driver of the jeep, my lord.
Hmm.
And he is also one of the merger witness, my lord.
He has not supported.
They have supported, my lord. All the prosecution witnesses have supported the case. PW6 is the IO, my lord, who has filed the charge sheet.
Then 7.
PW7, my lord.
7 Ilva.
7 to deposition copy, I don't have, my lord. That's the reason I couldn't speak out. PW7. You may be knowing this.
Yes.
My lord, the appellate court, my lord, on the reasons, my lord, that, my lord, that there are inconsistent evidence with respect of the date of occurrence, my lord. And, my lord, the appellate court also disbelieved the evidence of PW1.
Appellate court. Yes, what is the reason assigned by the first appellate court?
My lord, there are inconsistent evidence regarding the date of occurrence, my lord. The first reason is that, my lord. Then second reason is that, my lord, the forest officials, my lord, had carried the book of FIR, my lord. That the appellate court says that, my lord, which is impermissible and it creates doubt. And the third reason is that, my lord, no independent witnesses are cited in the mahzar, my lord. And the fourth one is that, my lord, the investigating officer has not complied with the mandatory provision by marking the billets, my lord.
Yes.
And the fifth one is that, my lord, the IO shifted the place of occurrence by taking the jeep near forest depot and drawing mahzar there, my lord. That is also one of the irregularity, my lord. And the offense was not reported to the higher officer, my lord. There is violation of mandatory provision under section 62 subclause 3 of the Forest Act, my lord.
Yes.
And for all these reasons, my lord, the appellate court holds that investigation is not proper. And hence, the accused are entitled for the acquittal, my lord.
Yes. What do you forest? What 64(3) say?
62 subclause 3, my lord.
62.
Subclause 3, my lord.
Yes. Report of such seizure.
Yes, ma'am.
This is not complied with.
Sorry, my lord.
This is not complied with.
No, my lord.
Yes.
My lord, with respect of the inconsistent evidence regarding the date of occurrence, my lord, the appellate court says that, my lord, the PW1 says that, my lord, it is on 22/12/2006, and then early morning, my lord. And another witness, my lord, they say that it is on 21/12/2006, my lord.
Yes.
It is in the early morning at 5:30 AM, my lord. My submission, my lord, there is no inconsistency in the evidence, my lord. They say that on the night of 22/12/2006, my lord, they were put to the duty, my lord. Patrolling duty they were put to. And at around 5:30 AM, my lord, they apprehended the accused number 1 and 2.
Evidence of PW1.
Please, my lord. May I read the evidence of PW1, my lord?
No, he says on 22/12/2006, Ratri Gastu Kartavya.
ರಾತ್ರಿ ಗಸ್ತು ಕರ್ತವ್ಯಕ್ಕೆಂದು ನನ್ನ ಮೇಲಧಿಕಾರಿಯವರು ಕಳುಹಿಸಿದ್ದರು.
That
And
was
my
on
lord,
22nd, not 20.
That is on 22nd, my lord.
ಬೆಳಗಿನ ಜಾವ 4 ಗಂಟೆಗೆ ವೆಹಿಕಲ್ ಬಂತಂತೆ.
Yes, my lord.
That means that will be on 23rd.
There is slight confusion with respect of the date, my lord. That will not take away the entire case of the prosecution, my lord.
Yes.
And my lord, the appellate court says that, my lord, though no independent witnesses were cited in the merger, my lord. It was in the early morning at 5:30, my lord, that too in the forest area, near the forest area, my lord. They couldn't find any independent persons at that time, my lord. And my lord, the merger witnesses, my lord, the daily wage worker of the forest department only, my lord.
Yes.
And my lord, merely they were working for the department, my lord. Their evidence cannot be brushed aside, my lord.
No, other one is the driver of the jeep itself.
Driver of the jeep, my lord.
Driver of the jeep of the forest department.
Yes, my lord.
What is elicited from them? They are PW.
They are also, they also say on the same lines of the PW1, my lord.
Then
My lord, with respect of marking of the billets, my lord, the witnesses say that, my lord, it was marked, my lord. And the appellate court also says that, my lord, few of the billets were not marked, my lord. The other billets, my lord, have been marked. And the witnesses have also identified the billets, my lord.
yes. Yes.
Hence, my lord, the accused has not given any explanation in 313 statement, my lord.
Not marked before the trial court.
Pardon, my lord?
They were not marked before the trial court. No.
No, my lord.
No. Have you produced any photographs?
Photographs. It was marked before the trial court, my lord. It is
Photographs.
4 and 5 ಅಲ್ಲಿ ಇರೋ ಬೀಟೆ ಮರದ ತುಂಡುಗಳನ್ನು ನೋಡಿ ಗುರುತಿಸಿರುತ್ತೇನೆ ಅಂತ ಹೇಳಿ.
ಎಲ್ಲಿದೆ ಎಮ್ಮೋ ಬೇಕಲ್ಲ? ಎಮ್ಮೋ ನಿಲ್ಲಂತ ಗುರುತಿಸಿದ್ರೆ ಮಾರ್ಕ್ ಮಾಡ್ಬೇಕು.
ಎಮ್ಮೋ ಮಾಡಿಲ್ಲ my lord. The photographs. P4 and 5 are the photographs.
ಏನಿದೆ ಇದ್ರಲ್ಲಿ? ನೋಡಿ, ಇದು ಕೊಡಿಯೋದಿಲ್ಲ. Look at the photograph. Can it be said as billets?
Oh my lord, I have seen the photographs. What is it?
Then why the mahzar was not drawn at the scene of occurrence? This photograph pertains to.
My lord, in the evidence of PW1, my lord.
No, you come to page, exhibit P6, the mahzar. 5 pieces of billets is different, which are
Sorry, madam?
5 pieces of billets transported in the jeep is, they are different. And there is again reference to 7 billets which were stored inside the forest area. I think the photograph pertains to those 7 pieces.
Yes, ma'am.
But where is the 5 other pieces carried in the jeep? ಸಾಗಾಟ ಮಾಡಿ ಬಾಕಿ ಉಳಿದ 7 ನಾಟಗಳನ್ನು ಗುತ್ತಿಯ ಬುಡದಲ್ಲಿಯೇ ದಾಸ್ತಾನು ಮಾಡಿಟ್ಟಿರುವುದು ಕಂಡುಬಂತು. ಅದನ್ನು ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ. ಸೊ 7 + 5. Inconsistency, total inconsistency.
Yes, sir.
Master clearly says 5 + 7. The objects were not produced.
Not produced.
Even the photo pertaining only 2 photographs. ಅದೆಲ್ಲಿ ಹೊಸದಾಗಿ ಕಾಣಲ್ಲ, ಏನೋ ಹಳೆಯದೇನೋ ಇದ್ದಾಗಿದೆ. 4 and 5. If it was produced before the court, why it was not identified? So Mahazar at a different place.
Yes, my lord. It was at a different place Master was drawn.
Then yes, anything?
This, nothing else, this being an appeal against acquittal, my lord, unless there is perversity, my lords, the Honorable Appellate Court would not interfere with the well-reasoned judgment, my lords. Para 21 to 23 of the Appellate Court judgment, my lords. Valid reasons are assigned. They cannot be held to be perverse in any manner. And moreover, my lord, unless the material objects are there, there cannot, that's the foundation for the prosecution.
Yes.
Please, my lords.
The state represented by so and so has preferred this appeal. Impugn the judgment dated 1st June 2016, passed in criminal appeal number 5 of 2014 on the file of the learned second additional district and sessions judge Kodagu Madikeri, sitting at Virajpet, allowing the appeal preferred by the appeal, setting aside the judgment of conviction and order of sentence dated 27/12/2013, passed in CC number 344/2010 on the file of the learned civil judge and JMUC Konnampet, trial court, and consequently acquitting the accused for the offense under section 104A of Karnataka Forest Act, Rule 130, section 104 of the facts of the case are that the forest officials, the informant being the forester, lodged the first information against accused number 1 to 3, contending that on 22/12/2006, in the early hours, accused 1 to 3 were transporting 5 blackwood logs in a Mahindra Jeep bearing registration number KA-12/EA-4003. When the Jeep was waylaid and it was verified, it was found to be the forest product. being transported by the accused without any license or permit. The accused have also removed the blackwood tree from a private land bearing survey number 30/6 belonging to one Uttamani M. Subhas. Subhas. Thereby they have committed the offense punishable under section so and so, so and so. It is stated that the forest officials seized all the wooden pieces found in the jeep as well as found in the private land under a Caesar Mazer. After investigation, charge sheet came to be filed. The accused have appeared before the trial court and pleaded not guilty. The prosecution examined PWs 1 to 7, got marked exhibit P 1 to 7 in support of its contention. The accused have denied all the incriminating materials available on record, but have not chosen to lead any evidence in support of their defense. However, they got marked exhibit D1 and 2 during cross-examination of prosecution witnesses. The trial court, after taking into consideration all these materials on record, convicted the accused with a judgment convicted accused number 1 and 2 with a judgment dated 27th December 2013, while acquitting accused number 3. Being aggrieved by the same, the accused 1 and 2 have preferred criminal appeal 5 of 2014. The first appellate court on reappreciation of materials on record allowed the appeal, set aside the impugned judgment of conviction and order of sentence passed by the trial court, and consequently acquitted accused number 1 and 2. Being aggrieved by the same, the state is before this court. Also, HCCP submitted that it is the specific contention of the prosecution that the accused number 1 and 2 were proceeding in the jeep, and they were transporting blackwood, 5 pieces of blackwood logs. They have also shown 7 wooden blackwood pieces in the private land, which were seized under the Hazard Exhibit P6. The prosecution examined the forester who valued the jeep as PW1. The Mazar witnesses being the daily wage worker and the driver of the jeep of the forest official as PW2 and 5. The deputy range officer and the range officer were examined as PW3 and 4. The investigating officer as PW6. On the basis of the oral and documentary evidence placed by the prosecution, the trial court rightly convicted the accused 1 and 2. But the first appellate court committed an error in acquitting the accused on flimsy grounds. Next parallel counsel submitted that the trial court has made much of the evidence of PWs 1 and 2 to arrive at a conclusion that there is inconsistency in stating about the date of occurrence. It is the first appellate court has formed an opinion that the IO has not marked the bullets while seizing, and the Mahazar was drawn at different places. It is also held that there is non-compliance of requirement under section 62(3) of Karnataka Forest Act, and therefore acquitted the accused. LCCP submits that the inconsistency found in the evidence of PWs 1 and 2 is a minimum one, and it will not go to the root of the matter. Since the incident had taken place in the wee hours, wee hours, the court could not have expected any independent witness to be present while drawing the matter. There is no inconsistency in the place of, in the scene, in the stating the scene of occurrence. Therefore, the first appellate court committed an error in acquitting the accused, accordingly she pays by allowing the appeal and to convict and to restore the judgment of conviction. Per contra, when the senior advocate for the respondent opposing the appeal submitted that the evidence of PW1 and 2 is inconsistent, even with regard to the date and the time of occurrence. The same cannot be reconciled. It is stated that the Blackwood logs were seized in the presence of PW2 and 5, who are none other than the workers in the department. No independent witnesses are made available for drawing the mansard and seizing the articles. There is non-compliance of section 62(3) of Karnataka Forest Act, which vitiates the entire proceedings drawn by the investigating officer. Even as per the mansard, it was drawn at the place, at a different place than the place where the incident had occurred. Taking into consideration all these materials on record, the first appellate court rightly acquitted the accused. Do not call for any interference by this court, as it cannot be branded either as perverse or illegal. Hence, praised for dismissal of the appeal. There is the material point for consideration. My answer to the point in the negative for the following. It is the contention of the prosecution that the accused 1 and 2 were proceeding in the jeep on the early hours of 22nd December 2006 near Pannampet Old Government Depot. They were not possessing any license or permit to transport the wooden logs. They stated that on waylaying the jeep and on inquiry, it is found that they were not having any license or permit. Petition license or permit to transport the logs. The accused have shown the other wooden pieces concealed in the private land bearing survey number 30/6 belonging to one Uttamani Subhas. All the wooden logs were seized under the Mahazar Exhibit P6 in the presence of PW2 and PW5. After investigation, charge sheet was to be filed. To prove this contention, the prosecution examined PW1, the forest officer. This witness stated that he was deputed for the night duty on 22nd December 2006. And on the next day, early morning at 4 a.m., he found the jeep transporting the Blackwood logs, which was subsequently seized under the Mahazar. But PW2, who is a daily worker in the forest department, who accompanied PW1 and who is the Mahazar witness to Exhibit P6, deposed before the court that he was deputed for the night duty on 21/12/2006 And then on the next day, early morning, the accused were found transporting the wooden logs illegally. Even though such an evidence is given by PW1 and 2, the inconsistency was not tried to be corrected by the learned prosecutor, who was supposed to be careful to clear the ambiguity in the evidence of the prosecution witnesses. No effort whatsoever appears to have been done by the prosecutor for the reasons best known to him. It appears he was a mute spectator in the court, and he has also not explained the inconsistency in a reasonable manner. This inconsistency with regard to the date of occurrence goes to the root of the matter. Next. According to the case made out by the prosecution, the blackwood logs were marked by the investigating officer while seizing it under Exhibit P6. As per the evidence, the witnesses have identified the logs, but strangely, none of them were identified as material objects. The prosecution got marked Exhibit P4 and 5 the photographs said to be pertaining to the wooden logs. But on seeing the photographs, Exhibit P4 and 5, they do not appear as wooden logs or billets. There is no explanation for the same. When the material object itself is not before the court, it is hard to believe the case made out by the prosecution. Moreover, as per the informant, there were 5 wooden blackwood billets being transported in the jeep by accused number 1 and 2. And later, they have shown 7 other blackwood pieces in the private land, in the land of a private person. It is not explained where all those 12 pieces are gone. Neither the pieces were produced before the trial, nor the photographs of the same are produced. These inconsistencies in these lapses on the part of the investigating officer go to the root of the matter, and the accused is entitled for acquittal. Next part. The first appellate court. I have gone through the impugned judgment passed by the first appellate court. It has taken into consideration the materials on record and formed an opinion that the prosecution has failed to prove the guilt of the accused beyond reasonable doubt. For various reasons referred to in the judgment. The reasons assigned by the first appellate court cannot be dubbed either as perverse or illegal. They are the reasonable conclusion that could be arrived at by the court. Hence, I do not find any reason to interfere with the impugned judgment of acquittal passed by the first appellate court by forming a different opinion. The trial court proceeded to convict the accused without taking into consideration all these lapses in the case made out by the prosecution. Therefore, the judgment of conviction passed by the trial court was rightly set aside by the first appellate court. In view of the above, I answer the other point in the negative and proceed to prosecution.
Yes. May I request one thing, my lord? Some amount, fine amount was deposited, my lord. The trial court be directed, my lords, to release.
Appeal is dismissed. Fine amount, if any, deposited by the respondent is ordered to be refunded on due identification.
Lordship, kind permission.
Hmm.
In fact, while releasing the Jeep, your Lordship, 80,000 has been deposited before the Chief Conservator of Forest, your Lordship.
Hmm.
That amount may be ordered to be released.
What happened to that proceeding?
That
Entirely
is ended,
different.
your Lordship. That is the Jeep has been released and these accused have deposited that 80,000 rupees.
It was not confiscated.
No, it was. Then they filed an application and they got it released.
Hmm.
There was a condition that they should deposit 80,000 rupees and that has been deposited. Now, in view of the
Really,
acquittal,
they are the gain materially.
Lordship, I'm sorry, I just, this is the order. As per the order, they have deposited before the,
You produce the judgment and get it released.
I'm just requesting your Lordship that they've deposited that 80,000.
You can get it back by producing the judgment.
Only one sentence about that would.
We do not know what is the proceeding before the deputy conservator.
No, only thing, the Jeep which has been confiscated, which was seized, that Jeep has been released on a condition that the accused number 1 has deposit 80,000.
The interim custody was given to you.
Please.
And thereafter, a separate proceedings will be held by the conservator of forest. He is authorized to confiscate the Jeep. It is altogether a different proceeding.
The Jeep has been released, your
No.
that is.
Released
Well,
to
yes.
your interim custody. Interim custody is different from confiscating the Jeep.
In view of this, I'm just
I don't know.
submitting,
You
humble
go before the
submission.
conservator of forest. You produce the judgment,
Please.
get it. That's it. Next.
Grateful, madam.
Serial number 62, Ravindranath K.
If there is confiscation,
Yes,
your
please.
separate appeal, you have to prefer. You have to prefer.
Please, wait.
You cannot seek the relief in this appeal.
No, I just
This
bring it
way
to
I-
your honest notice that in case if that,
Fine amount,
please,
right, you are entitled. But
please,
I do not
great,
know what is the proceeding before the conservator of forest.
please, great.
Yes.
Lord, notice has not been ordered to be sort of.
Admission legal.
The notice has not been ordered.
Yes, make out a ground for admission.
Lord, the appellant is complaint before the Lord trial court,
138.
138.
Ah.
The accused and the Lord, the complainant are friends.
Hmm.
Lord, and the accused, my Lord, he is admitted, my Lord, in the, Lord, even in the trial court, before the trial court, he has taken a 5,000 and issued the check.
Hmm.
But, my Lord, wherein, my Lord, the complainant's, my Lord, the case, that, my Lord, he has checked and the, my Lord, almost 14 lakh change from the, my Lord, the complainant.
No, what is the amount lent by you?
Lord, 14 lakhs, my Lord.
Exactly.
No, 14 lakhs. Lord,
63,070.
63,000, Lord, 70 rupees.
Why that figure?
Lord, that is
Why
what-
it was lent?
Lord, that is what, my Lord, because with interest, my Lord, that is what I verified, because.
No,
it's
no,
cap-
no, no. Along with interest Allah. Your contention is that the accused borrowed a sum of rupees 14 lakh 63,070.
True, my
Why
Lord.
that figure? Huh?
Lord, that is what, my Lord, verified, because that is what amount he has paid. My Lord, because some, my Lord.
There must be some specific reason.
Specifically, that is, my Lord, as your Lordship is pointed out, even the trial judge is
First
also been
sentence
pointed.
led out.
Because there, my Lord, I verified with the, my Lord, client, because none of these things has been come out in the complaint, or, my Lord, why this amount has been paid and the particular, the, my Lord, not the exact amount which is not been correct, made. But, my Lord, he has said some religious purpose, something, my Lord, he has paid the amount when he asked. That is what I, Lord, he have verified with the client. So that is what he has told me, my Lord, when filing this appeal. So on that issue, my Lord, but anyhow, my Lord, but that is not been even, because legal notice has been issued to the, my Lord, the accused. Lord, he has, even he is, at least, my Lord, he has received the legal notice, at least he has not even, my Lord, said that he is not there.
What is the defense taken?
No, he has not taken any defense, he's not even, he said that he has issued the
There is
5,000.
no cross-examination.
No, but he is not step into the, my Lord, witness box.
There is no cross-examination to PW1.
For PW1, there is a cross-examination by the accused advocate. But he is, the accused is not entered to the witness box.
Let him not. But what is the cross-examination? What is the defense taken during cross-examination?
Kindly see the cross-examination, my lord, only 2 pages cross-examination, my lord, LCR is also been received. This was done on 9/8/23.
Sir, it runs into several pages.
No, no, my lord, only.
Tell me in nutshell, what is the difference?
Lord, only has taken that, he has not paid the amount, only has taken 5,000,
Only 5,000.
yes, taken.
Oh.
And yes, subsequently, the cross-examination, you have no, my lord, capacity of lending the, that huge amount to the accused. And one more, my lord, he said, because since the check has been issued in the name of R&B Associates, because he's the sole proprietor of that, my lord, and the said my lord, established was not made as a party to the proceedings. This is what said, but I am the sole proprietor of that R&B Associates. Lord, I have, being the my lord, proprietor, I have presented the check.
RV Associates.
RV and Associates. My lord, I have
Have you
produced it up-
stated so in the complaint?
Yes, yes, my lord. I have stated in the, my lord, even in the, my lord, the documents are also produced in the, my lord, in respect of the, my lord, the R&B Associates, GST certificate, Exhibit P, my lord, 10. And bank statement is also produced, Exhibit P 11, my lord. Sorry. Timmappa Ramesh, that is a complaint, and R&B Associates.
Yes, in the complaint, what you have stated about the complainant?
Not in the complaint, my lord, he has taken the amount, my lord, for his domestic purpose and business purpose. But that is para 3, my lord. Lord, I may be permitted to read the complaint, my lord, the para 2. The complaint submits that the accused and the complaint are well known by my client from several years, and out of this cordial regime, you have borrowed a sum of rupees so and so from a complaint 4th January on domestic purpose and for his business and financial needs. And also the accused have agreed to repay the same after a lapse of 11 months. Lord, even legal notice has also been issued into that effect after the Lord, the check returned with the insufficient fund. The notice was also issued on my lord to the accused on 16/11. And it is received, but my lord, no reply has been sent. If at all, my lord, even only in the my lord, after serving the summons by the court, he has come and appeared that my lord, he has not produced any document, only burden was my lord, shifted on the complainant to my lord, prove his case. But he is not even step into the witness box, at least to elicit something, my lord, from the accused. Even on, as your lordship is pointed to, only on 2 technical ground, my lord, because this check was issued in the name of R&B Associates, though R&B Associates is not made as a party. Then one more, my lord, assets that the figure which has been your lordship has pointed out similar, my lord, contentions, my lord, taken by the learned trial judge and dismissed my complaint. But he admitted in the my lord, check which has been issued and for the amount which has been paid, taken, and my lord, the signature was also admitted. Even is not in the process of cross-examination, he has not even made any my lord, the specific question regarding about the my lord, the not issuing the check or issuing the check. Exhibit P1 to P11, my lord, which is a document, is very clear, my lord, that.
Whether you have declared this amount in the IT returns?
Lord, as per my knowledge, it is not done, my lord.
Then why you had produced exhibit?
My lord, it
P6?
is only because it is paid in the cash. That's why, my lord, because it's all statement of the, my lord, the company. That is also, my lord, in the complaint I
What is
stated.
your avocation?
My lord, I am the businessman.
What business?
My lord, I'm doing some business in the, my lord. That exactly. Lord, due to that, my lord, even income tax, my lord, other.
Nothing has been stated in the complaint. Who is this RV Associates?
In the
What it was
cross-examination,
dealing with?
in the cross-examination, that is a, my lord.
Sir, complaint ನಲ್ಲಿ ಏನಿದೆ?
Complaint only because it is because I have.
Directly, I have given 14,63,070.
Because, my lord, they are both are very friends, my lord, good friends.
Even
Because
if,
it's considering the, my lord, cordial relationship, the amount which has been paid. That is what, my lord, the contention which has been taken in the, my lord, plea which has been taken in the complaint.
the two for domestic purpose.
And even business purpose, my lord, both. Business also, my lord, as in the complaint I have stated, my lord. Domestic purpose and for his business purpose.
In what business the
Not
accused is
for
doing?
accused, because he is also, my lord, into the similar business. That's why, my lord, if he has come out.
Similar ಅಂದ್ರೆ ಏನ್ ನಿಮ್ business ಗೊತ್ತಿಲ್ಲ. ಇನ್ನು accused ಏನ್ similar business. ನೀವೇನ್ business ಮಾಡ್ತೀರಿ ಅಂತ ನಿಮಗ್ ಗೊತ್ತಿಲ್ಲ. Similar business accused, so ಅದು ಗೊತ್ತಿಲ್ಲ.
If you allow permits, my lord.
10 rupees, 14,63,000.
I have it tomorrow, I'll verify, my lord, while.
ಬೇಕಾಗಿಲ್ಲ. But nothing is there in the complaint. That is
The
sure.
complaint, my lord, it is nothing, my lord. Only
It is as
stated
broad
it
as
is-
it is. ಏನಿಲ್ಲ ಇದ್ರಲ್ಲಿ.
Lord, even in the cross-examination, my lord, kindly see, nothing is, my lord, the serious questions which has been asked regarding about the, my lord, non-payment.
See, he has taken a specific defense that he had availed rupees 5,000 during October 2020. And at that time, you obtained the blank check.
Lord, that
That
is
was
his
the
case,
defense.
but is my case is, my lord, a different thing, because I.
Now the burden is on you to prove your contention. Why you have lent that specific amount of 14,63,000?
Because, my lord, there was.
That too without any document.
That too, my lord, only because in the cordial relations, my lord, between the.
You have
complainant
not
and the-
stated so in the complaint.
Yeah.
Kindly see, that is I have stated, my lord. He's a friend actually, my lord. He's a well-known, the para 2 of the, my lord, the complaint. The complaint submits that the accuser and the complaint are well-known to each, well-known to my client since from several years. Because that with the relationship, my lord, amount which has been paid.
No, sir.
My lord, that 5,000, my lord, he says, my lord, but it's blank, if anybody, my lord, in the 5,000 check, in any blank check will be, my lord, check will be given to security, my lord.
If you can say that I have lent 14,63,070 without any document, the defense taken by the accused that he has availed 5,000 and given
No,
blank check
my
is
lord,
to be
for a moment,
accepted.
my lord, for a moment.
It is to be accepted.
For a moment, my lord,
Why
it's a
not?
normal, for
Why
a normal course. Is there any, my lord, any persons can for only 5,000?
See,
Anybody will
normal
issue the
process,
check.
I'm
my lord.
asking you, can you borrow an amount of rupees 14 lakh at least today without any document?
No, that's why, my lord, only check which has been issued, exhibit P1 has been issued. My lord, to that effect, my lord,
Is
check
it
for 14 lakhs, he has issued the check, my lord. That is the only document which has been given by the, my lord.
it was a post-dated check?
Yes, my lord, post-dated checks.
Have you stated so in
Yes,
the
my lord, yes,
complaint?
my lord. Kindly see, my lord, issued the dated check bearing number so on, so posted, even in the notice also I have issued, my lord.
No, where you have stated in the complaint,
Kindly
sir?
come to, my lord, my legal notice, my lord. My legal notice, exhibit P, my lord, 3. I have stated in the exhibit P3.
No, sir. ಇದೇನು,
It
it won't,
kindly see, my lord, final para 2 only, the 11, the accused has have agreed to repay the same after lapse of 11 months. And hence the accused have issued a post-dated check. In the complaint, what my lord, I'm saying. Post-dated check bearing number 163714 drawn in Canara Bank, Vasmane extension, Badravati, for a amount of rupees 14,60,070. This is what I have stated. Lord.
your contentions cannot be believed even for a moment.
No,
Even for a moment.
Lord, it is only because he is not disputed issuing the check, my lord. Only is disputing the amount. He's only disputing the amount.
Yes, that is why the
No,
burden is on
because,
you.
because when he.
That is why the burden is on you
That's
to
why,
prove
Lord,
lending of the amount.
That was, my lord, because even I stated it is given by cash. Because to that effect, there is no cross-examination.
You are an income tax
Yes,
assessee.
my lord.
14 lakhs you paid in cash without any document,
My lord, where that,
without disclosing it in the income tax returns,
because since it is paid, because as per my law, it is paid in the cash, my lord.
not
And-
cash, black money. Otherwise, there cannot be any justification. Simply saying that we are cordial, we are friends, we are having cordial relationship, lent an amount of rupees 14
Please,
lakhs, that not
let-
to
let-
the
my lord,
round
my-
figure of 14 lakhs,
Let-
14
my
lakhs,
respect-
63,070.
My respective submission, at least, my lord, issue the notice, at least appear, because
Yes,
all this, no,
there is
the
nothing.
accused, at least,
There
my
is
lord,
nothing.
no,
There is nothing.
because why, my lord, respective submission, at least any, my lord, chances of it,
No,
supplement or something
no.
like that.
ಇದೆಲ್ಲ ಆರ್ಮ್ಸ್ ಟ್ವಿಸ್ಟಿಂಗ್ ಮಾಡೋದಿಲ್ಲ, ಇಲ್ಲೆಲ್ಲ ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದೆ, ಇದ್ ಮಾಡಿ.
No, nothing, my lord, even,
But-
it's not like that, my lord. Kindly issue legal, at
No,
least
sir,
notice
sorry,
by
you
someone.
have not made out any ground for admission, sir. There are no merits in the country. The appellant before this court seeking impugning the judgment dated 18th August 2023, passed in CC number 12 of 2022 on the file of the learned second additional civil judge in JMFC at Patara, acquitting the accused for the offence punishable under section 138 of MI. The facts of the case are that the complainant has filed the private complaint in PCR 482 of 2021 against the accused, alleging commission of the offence punishable under section 138 of MI. It is the contention of the complainant that he was knowing the accused since several years and lent an amount of rupees 14,63,070 on 4th January 2021 to meet his domestic and business requirements. The accused had issued the proceeded check bearing number 163714 drawn on Canara Bank for the said amount, which was bearing the which was dated, which is dated 7/11/2021. When the check was presented for encashment, the same was dishonored as there was insufficient funds. Even though the legal notice was issued and served on the accused, he has not repaid the check amount nor issued any reply notice. Thereby, the accused has committed the offence punishable under section 138 of MI. Accordingly, he requested the trial court to take cognizance of the offence and achievement. Trial court took cognizance of the offence and registered CC number 12 of 2021. The accused has appeared before the trial court and pleaded not guilty. The complainant examined himself as PW1, got marked exhibit P1 to 11 in support of his contention. The accused has denied all the incriminating materials available on record, but has not laid any evidence in support of his defense. The trial court, after taking into consideration all these materials, passed the impugned judgment acquitting the accused, holding that the complainant is not successful in proving the guilt of the accused beyond reason. Impugning the said judgment, the complainant is before this court. Complainant counsel for the appellant on admission. Counsel for the appellant submits that since the accused was very well known to the complainant, he had lent rupees 14,63,070 on 4/1/2021. The post-dated check as per exhibit P1 was issued by the accused towards discharge of the debt. The same was deemed to be dishonored as there was insufficient fund. The accused has not issued any reply notice even after service of notice on him. The accused has not stepped into the witness box to depose about his defense. For such circumstances, the contention taken by the complainant, which is spoken to by him by examining himself as PW1, is to be believed. Trial court committed an error in acquitting the accused. Hence it pays for allowing the appeal. Tell you the materials, including the trial court record. Point for consideration, my answer to the point in the negative for the following reasons. It is the contention of the complainant that he had lent an amount of rupees 14,63,070 on 4/1/2021. And the accused had issued the post-dated check on the very same day, which was dated 7/11/2021. When the check was presented for encashment, it was dishonored as insufficient. In spite of issuance of legal notice, the accused had neither repaid the check amount nor applied to the notice, and thereby he has committed the offence under section 138 of NA. To prove this contention, the complainant examined himself as PW1. The tenor of cross-examination to PW1 is that the tenor of cross-examination of PW1 discloses that the accused has taken defense that he had borrowed an amount of only rupees 5,000 from the complainant and had issued the blank check with his signature as security. The complainant has misused the same and presented for rupees of 14,63,070, which is an imaginary figure. Thus, it is clear that the accused has admitted issuance of the check with his signature, but has taken a defense that he had availed loan of rupees 5,000 and had issued the blank check. Once the accused admits issuance of the check with his signature, the presumption under section 139 of the law would arise, and the burden shifts on the accused. It is settled proposition of law that the accused, in order to probabilize his defense and to rebut the presumption, need not have to produce any material, nor it is required for the accused to step into the witness box to depose about the defense. If during cross-examination of PW1, the accused elicits the answers which could make the court disbelieve the version of the complainant, then it could be said that the accused is successful in rebutting the presumption by probabilizing its defense. PW1 is cross-examined by the accused at length. During cross-examination, witness states that he had not obtained any document for lending the amount. On the other hand, he lent the loan in cash. Strangely, even though the complainant is an income tax assessor, he had not declared this loan of rupees 14,63,070. Moreover, there is no explanation as to why this odd figure of 14,63,070 was lent by the complainant. Even though the complainant has produced the income tax returns with the acknowledgement, as per Exhibit P6 and 7, admittedly, he has not declared lending of the amount in favor of the accused. Complement has produced exhibit P8, the statement of account pertaining to the complaint issued by Canara Bank. Pertaining to Messrs. RV Associates. Joint holder Ramesh T, that is the complainant. For the statement. As on 4th January 2021, that is on the date of loan according to the complainant. The amount that was available in the account was only there was a negative balance in the account. And there was withdrawal of rupees 3,86,960. 3,86,906. 906. It is stated that the complainant is having overdraft facility in the bank. Exhibit P9 is the similar statement of account issued by Canara Bank. According to which on 4th January 2021, the balance available in the account was rupees 16,505. As rupees 15,000 was deposited on the same day. Therefore, neither exhibit P 8 or 9 would substantiate the compulsion of the complainant, but he had sufficient amount at his disposal. Moreover, when the accused specifically denied availing of such huge amount of rupees 14,63,007, the complainant has not explained as to why he has lent such odd amount to the accused, why there was no document evidencing the lending, and why he, being the businessman, lent the amount in cash, which was never disclosed in the income tax returns. From all these materials, I could safely conclude to state that even though the accused is successful in reverting the legal presumption by raising a reason possible defense, from our complainant has failed to prove lending of the amount, and therefore he failed to prove the guilt of the accused beyond reasonable doubt. And therefore the accused is entitled for acquittal. I Next, I have gone through the impugned judgment. Appeal is dismissed.
Please, compliance.
Serial number 63, Akram Pasha, Gaurav Singh.
I appear for the respondent in this case, ma'am.
When the counsel for the petitioner is absent, no representation.
My lady, may I make one small submission? I've been suffering an interim order of stay of the trial since so many years now.
Yes.
My only request is a date may kindly be fixed. The stay was only granted on one fact, that there was an FIR which was filed in favor of the petition.
Why do you say so? Interim order never extended. When it was granted?
29/9/2021, your ladyship. And the trial has been pending ever since. Memo. I have procured the RTI.
Which is the order which is impugned.
It's 25/10/2017, my lady. The order sheet, my lady may find it at page number 12.
Tell me about the facts of the case.
Please, my lady, the complainant, which is the respondent before this honorable court, has supplied lenses, eye-making lenses. The petitioner before this honorable court was the distributor. Lenses were supplied, invoices were raised.
It was supplied lens.
Eye lenses. Only
Contact
the
lenses.
ophthalmic lenses.
Contact lenses.
Ophthalmic lenses, the eyewear glasses, the lenses which comes, only the lenses were supplied to the distributor. We are in business for over a decade-long period. Thereafter, the invoices fell due and a check was issued. Check dated 1/3/2017 for an amount of 8,15,510 rupees. That ultimately, your ladyship, went bounce. After that, trial was commenced and cognizance
For
was
what
taken.
reason? Funds insufficient.
Funds insufficient. It was, I stand corrected, my lady. It was bank account closed.
Then,
It was returned on 9/8/2017.
yes.
After that, a legal notice was issued.
Was it served?
It was served and delivered.
No reply.
There was a reply notice also on 23/9/2017. It
What's
is
the
also at
difference?
page 36.
What was the defense?
The defense was that the bank account was closed. That's all was mentioned, and it was communicated to complaint is what they allege in the reply. And they also mention at para 4 of the reply at page 37, if your ladyship may kindly peruse, that it was issued for security purpose. It was their defense.
No, having the dealings, business dealing is denied,
No, business dealings has never been denied. The transaction has never been,
admitted,
it's been admitted.
illegal.
It is also admitted on the petition itself, my lady. I'll just highlight the exact page number. Paragraph 3 in the reply notice, the transaction and the business has been admitted. At page 15 and page 9 and 37, para 15 in the petition itself, the business dealings between both the parties has also been admitted. The simple line of defense.
Check. Date of check.
Date of check is 1/3/2017, 1st of March 2017. Date again. Malay 12/7/2017, I stand correct. That's 12th of July 2017, the check date.
12th of
July, 12/07/2017. May I read out the para from the reply,
1 minute.
please?
What is the order that is impugned here?
My lady, the order passed by this honorable court was on basis of a memo which was filed by the petitioner on the date of hearing, that there was some police complaint which was lodged for loss of check, the said disputed check. That police complaint, my lady may find it at
No, I am asking you, what is the impugned order? 8/3/2018.
the impugned order. He's challenging the order taking cognizance.
Where is it? Page number.
1 second. Starts at page number 12. Operative is on 14.
Yes, so good.
May I just produce one important vital document here? Your lady, I have procured one information from RTI, whether an FIR was actually lodged or not, because the memo which was filed only gave a snapshot of the police complaint which was filed. May I kindly place that on record?
Ian, what is there?
The information which has been given by the police department is that no FIR has ever been lodged in that matter, and the inquiry was conducted and closed without finding any tracing any check whatsoever. May I just place these documents on record, the original RTI application and the response?
According to the accused, the check leaf was stolen.
Stolen, and he has filed a complaint.
Stolen by?
He doesn't name anybody in the complaint. And that is interesting because even in his reply, he doesn't plead loss of check. Even in this petition before this honorable court, he never pleaded loss of check. The first time, only in the memo, he pleaded loss of check.
Yes, okay. Learned counsel for the petitioner is absent, no representation. Page number, first again, petitioner being the accused. In, I got it. 218. CC 52762 of 2018 on the file of so and so is impugning the order dated 8/3/2018, taking cognizance of the offense punishable under section 138 of an act and registering the criminal case against him. The facts of the case are that the respondent as complainant filed PCR 5833 of 2017 before the trial court against the accused, alleging commission of the offense punishable under section 138 of an act. It is the contention of the complainant that he was dealing with optical lenses and supplied the same under various invoices to the accused, who was also doing similar business. There was a due of rupees 8,15,510, and towards discharge of the amount, the accused had issued the check dated 12/7/2017 for the said amount, which was going to be dishonored on presentation with an endorsement that the account is closed. When the legal notice was issued, the accused had issued a reply denying that there was any amount that was due to be paid to the complainant and contended that the check in question was lost. It is also contended that the accused admitted business transaction with the complainant, but contended that the last transaction was on 27/12/2016. And the bank account was closed on 19/12/2016 as he closed down the business. Therefore, the accused denied his liability to pay the check amount by issuing the reply. The complainant has filed the private complaint alleging commission of the offense punishable under section 138 of an act. The trial court took cognizance of offense by passing the order dated 8/3/2018, which is impugned here. When a counsel for the petitioner is absent, there is no representation even when the matter is posted finally as a last chance. Third, learned counsel for the respondent. The counsel for the respondent contended that the accused never denied the business dealing with the complainant, rather it is admitted. According to him, he has closed down the business. He contends that a blank check was issued as security and the same was misused by the complainant. When the accused admits business transaction, it is for him to prove a business transaction and admits issuance of the check with his signature. Presumption under section 139 would arise, and the burden is on the accused to prove his defense, if any, before the trial court. There are prima facie materials to prove commission of the offense, and on the basis of the same, the trial court proceeded to take cognizance of the offense by passing a detailed order. The counsel also submitted that even though it was tried to be contended by the complainant that the check in question was lost, and he has filed a complaint and an FIR came to be registered, comma, he procured the document to show that no such FIR was ever registered by the police. Even though, in fact, a complaint, when the complaint was filed by the accused regarding loss of check,
On 14/8/2017, page 17 of the memo filed by the
14/8/2017, when the check was presented for encashment.
8,000. 5 days after the check was.
Was filed on 14/8/2017, that is much after presentation of the check dated 12/7/2017 on 9/8/2017 for encashment. In spite of that, no FIR was registered, no inquiry was held. Under such circumstances, the contention taken by the petitioner does not serve any purpose and prays for dismissal of the petition. Read the materials, including the grounds made out in the petition for impugning the order taking cognizance. The petitioner admits that he was running the business under the name and style as Messrs. Frontier Labs Guwahati, and he closed down the same on 18/3/2017. The reply notice dated 23. What is the date of reply? 23/9/2017.
Yes.
He is produced before the court. According to which, the accused who was running the business was lost transacted with the complainant company on 27/12/2016. And the bank account was closed on 19/12/2016. As he closed down the business, he has closed down the business. The defense taken in the reply notice regarding closing down the business, date of closing down the business, do not match with the grounds made out in the petition. According to the petitioner, he had issued the check exhibit P1, sorry, he issued the check dated 12/7/2017, but it was a blank check issued as security. Once the accused admits his signature, once he admits issuance of the check with his signature, the presumption under section 118 and 139 of NI Act would have, and the burden shifts on the accused to rebut the legal presumption. The complainant has filed with the private complaint, making specific allegations and complied with the requirements of law. For the purpose of filing the private complaint. The trial court, after perusing the documents, the affidavit filed by the complainant, formed a prima facie opinion that there are sufficient ground for taking cognizance and registration of the criminal case for the offence punishable under section 138 of the NIS. It is stated that the complainant has complied with the requirements under section 138 A to C of NIM. And prima facie opinion is formed that the check in question appears to be issued towards discharge of legally enforceable debt or other liability. And accordingly, the cognizance was taken, directed to register the criminal case, and the accused was summoned to appear before the court. When the materials that are placed before the court prima facie discloses commission of the offence, the learned magistrate was right in taking cognizance of the offence. The defense raised by the petitioner accused in the grounds of appeal could at the best be the defense taken before the trial court. But the same cannot be a ground before this court, requiring the court to hold a mini trial to find out as to whether the offence in question is committed or not. When there are prima facie materials are placed by the respondent complainant before the court regarding commission of offence punishable under section 138 of the NIM, I do not find any legality or perversity in the order passed by the law. Hence, I do not find any reason to admit the petition or to allow the same. Accordingly, I answer the above point in the negative. Petition dismissed. ಯಾವ್ದಿದೆ ಕರೀರಿ.
Non-compliance with office objection for first time, serial number 1, BM Mohan Kumar.
Then list on full purple. Next.
Serial number 2, Nandini Siddharth Nijaganavar.
Same. Next.
3, Shivaprasad S.
Same. Next.
4, Shashwat S. Prakash.
Same.
5, Chakravarti P.S.
Same.
6, M. Krishna Gowda.
Next.
Orders first time matter, serial number 7 to 9.
Issue notice. Then SCP to take notice for respondent, private Idre. Yes.
Serial number 10. Vikram Raj.
Kindly have it tomorrow, Your Worships.
Serial number 10.
10.
Or appeal. Counsel for the petitioner prays for time. Finally, yes. Next.
Grateful.
11, Kiran S.S.
Appeal for petition, my lord. Petition under section 439, my lord. Offence is under section 376, 448 and 506 of IPC, my lord.
Earlier, your petition was dismissed.
Yes, my lord. Filed by earlier counsel.
Counsel, that will not make any difference.
Not filed by me, my lord. Earlier, separate counsel filed and
You are not seeking the bail, sir. It is the accused who is seeking bail.
Yes, my lord.
Change of counsel will not make any change in the view that is taken by the court. So. What is the change circumstance?
Changes
On
for
merits, your petition was dismissed.
dismissed for non-prosecution, my lord.
No?
Here. Yes, Yes, my lord.
Who said? Order
I
dated
checked.
19 January 2023.
My lord.
Petitioner is Gangaraju.
Yes, my lord.
On merits, it was dismissed.
It is showing in online manner dismissed for non-prosecution.
I am having the detailed order, sir.
Criminal-
On merits, it was dismissed.
I will convey it, my lord. Kindly pass over after. But
Conviction ನಿಮ್ಗೆ dismiss ಆಗಿದೆ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ convince ಮಾಡ್ತೀರಾ?
it is only showing one case, my lord. Criminal petition number 11438/23, my lord.
ಮಧ್ಯಾಹ್ನ.
Dismissed for non-prosecution, my lord. Kindly pass over, my lord.
It's 2:30.
Number 4, second.
Hmm.
Kindly grant a week time right to supply the office of the death certificate acting also in.
ಏನು ಫೈನಲ್ ಏನದು?
Kindly grant a week time. Produce the death
Four.
certificate. Supply the office of the.
Respondent in the same matter.
Counsel for the appellant prays for a week's time to comply with the office objections raised on IA 2 of 2024. List down.
My lord, a copy of the application also may be served on us. The LR application has not
Counsel
been
for the
served on us.
respondent submits that the copy of IA 2 of 2024 is not furnished to the respondent. Counsel for the appellant undertakes to do the needful. Yes, next.
My lord, serial number 5, my lord, list number 2.
Hmm.
My lords, a week's time may be granted, my lords. We have contacted the party, my lords. The party is in out of station, my lords. We'll file necessary applications.
No, when the party, he died,
My lords, he died on 21/8/2023, my lords.
then it is already abated.
My
There
lords,
is the question of granting time.
1 week time may be granted, my lord. We'll file necessary application, my lords.
ಕೊಡಿ ಏನಿದೆ order sheet. What was the submission made on the last date of hearing?
My lords, we are,
Yes, the same submission.
my lords, finally, my lords,
Week's
finally
time
1
may
week
be
time may be granted, my lords. The party is in out of station, my lords. Therefore, we could not file necessary applications, my lords. Kindly, my lords, 1 week time may be granted, my lords.
The party in person ಯಾರೋ ಇದ್ರಲ್ಲ ಅವಾಗ? General power of attorney holder. Already abated ಅಂತ ಆಗೋಗಿದೆ. Counsel for the appellant prays for time. Miss Rashmi Manikempanna, said to be the general power of attorney holder of the respondent, is present and opposes granting of time. The order sheet dated is 6/11/2024 reads as under. In spite of that, in spite of that, no steps were taken to include the legal representatives of the appellant. It is noted that the appeal is already abated. I do not find any reason to adjourn the matter, however, therefore, one more opportunity, please finally as a last chance. Next.
One submission. List number 2, serial number 3, your lordship. Both parties are present, filing compromise affidavit, your lordship.
Madhyana, 2:30.
Passport appointment.
2:30.
Much obliged.
ಧಾರವಾಡ ಬೆಂಚ್ ಮ್ಯಾಟರ್ ಯಾರಾದ್ರೂ ಅಡ್ವೊಕೇಟ್ಸ್ ಇದ್ದೀರಾ ಸರ್?
Serial number 1, madam. Court officer.
ಸರ್ ಆಡಿಬಲ್ ಇದ್ದೀರಾ?
Please, madam.
Ashok Kumar Shetty. After receipt of PCR.
ಬರ್ರಿ ಇನ್ನು ಬರ್ತಾ ಅದೇ ಧಾರವಾಡ ಬೆಂಚ್ ಅಂತ ಹೇಳಿದ್ವಿ.
Machine ಕಲಿಲ್ ಪಾಪ. ತಿನ್ನಕ್ಕೆ ಇರ್ಲಂತೆ ಊರಿಗೆ ಗೋವಾಕ್ಕೆ ಹೋಗ್ತಾರಲ್ಲ ಗೋವಾಕ್ಕೆ ಹೋಗ್ಯಾರ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಇದೇನೆ, ಸೀರಿಯಲ್ ನಂಬರ್ 1. ಕೋರ್ಟ್ ಆಫೀಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಸರ್ ಮೇಡಮ್ ಬರ್ಲಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಇದೆ.
ಸರಿ ಸರ್ ಮೇಡಮ್ ಬರ್ಲಿ.
ಓಕೆ ಮೇಡಮ್. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಆಯ್ತಾ?
ಅಲ್ರಿ ಅವ್ರು
ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಮೇಡಮ್ ಹೇಳಿ.
ಮೇಡಮ್ ಗಿರಿಜಾ ಹಿರೇಮಠ್ HCGP ಧಾರವಾಡ.
ಹಾ ಮೇಡಮ್ ಓಕೆ. ಗಿರಿಜಾ ಹಿರೇಮಠ.
ಏನ್ ಮೇಡಮ್? ಗೀತಾ ಮೇಡಮ್ HCGP ನೋಡಿದ ತಕ್ಷಣ ಖುಷಿ ಆಗ್ಬಿಡುತ್ತೆ.
ಬೆಸ್ಟ್ ಯಾಕಂದ್ರೆ pertaining to Dharwad bench, serial number 1, RH Angadi,
My Lordship, the present petitioner was enlarged on bail by this honorable court. Wide order dated, my Lordship, 28th June 2021, which is at page number 84, my Lordship.
No, there is some office objection.
No, no, they are formal office objection. That is a typed copy of complaint they are seeking, my Lordship. Since I have sought for a relaxation of some bail conditions, my Lordship.
Third learned counsel for the petitioner on office objection at serial number 2. Learned counsel submitted since the complaint, whatever copy of the complaint produced at page number 8 is legible. Production of typed copy of the same may be dispensed with. Perused whatever copy of the complaint. The same is legible as office objection at serial number 2. In that regard is ignored. HCGP to take notice. Responding number 2 any complainant bedwa.
First, may I submit?
Yes.
The order passed by this honorable court is at page number 84, my Lord.
No, respondent, HCGP to take notice for respondent.
Please, Your Lordship.
Yes.
In my humble submission, only I am seeking relaxation of a condition since petitioner is intending to visit that is Baghdad, the place of worship, my Lordship, for only 10 days, my Lord.
Maybe,
So the
but
velocity
the
appears
government has to,
only.
the respondent is to be heard. Please furnish the copy to the learned HCGP. Next date of hearing, I'll consider that. Yeah, bola.
My request for early date.
Yeah, bola. Yeah, bola. 25th, Monday.
Please.
Hearing on IA, serial number 2, Naveen Chattar.
Lordship, in this case, I'm appealing for the appellant to Lordship. Your Lordship, the earlier Your Lordship, the Karnataka District Court was granted a bail to the accused on Your Lordship 2021. Subsequently, Your Lordship, the condition number 3 has been violated, and therefore he was rearrested, Your Lordship. After the rearrest, Your Lordship, the appellant has moved a fresh bail application. The same is came to be rejected, Your Lordship, only for violation of condition.
Now, what is this IA1?
I have for a dispensation of a certificate copy of complaint, Your Lordship.
Certificate copy of?
As a complaint FIR in charge, Your Lordship.
No certificate copy is produced.
Impugned order copy is produced, Your Lordship. Therefore, seeking dispensation.
Parliament Council for the appellant, IA1 of 2024, seeking dispensation from producing certificate copy of. It is noticed that certificate copy of the impugned order dated 2/9/2024 on the file of the Learned Second Additional District and Session Judge Bagalkote in a special case number 30 of 2021 is produced. Hence, the office objection. Hence, I find it appropriate to allow IAS also. Accordingly, I also allowed dispensed with.
You can request
For respondent. HCGP to take notice
Please.
for respondent.
For respondent number 1.
Issue notice to respondent number 2.
Your Lordship, I request for earliest date, Your Lordship, since he is in custody for more than 4 months.
No, notice is to be served on respondent number 2, sir. Private person.
Any date, Your Lordship.
Yes. Immediately after service of notice.
Please.
Yes. Next.
List 3, serial number 11, Kiran SS.
ನೀನು ಕನ್ವಿನ್ಸ್ ಮಾಡ್ತೀನಿ ಅಂದ್ರಲ್ಲ ಏನ್ ಮಾಡ್ಬೇಕೀಗ ಡಿಸ್ಮಿಸ್ ಅಲ್ಲಪ್ಪ ಆನ್ ಮೆರಿಟ್ಸ್ ಇಟ್ ವಾಸ್ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ನೌ ವಾಟ್ ಈಸ್ ಟು ಬಿ ಡನ್ Memo of withdrawing, file it. Counsel for the petitioner. Filed a memo seeking permission to withdraw the petition. Memo is pleased on record, petition dismissed as withdrawn.
Serial number 12, adjourned, 13, Karthikeyan.
Clear it was disposed of on merits. 1 minute. Hmm. Hmm. Yes.
Therefore, he makes a right and seizes certain articles. None of the necessary provisions have been applied as in the special action. That is one of the and most important thing what I would like to read. Page 3.
What was there, to say that there is non-compliance? What is that? Why? No, it was a on credible information. Howdu? Where was the petitioner then? Where was the petitioner then? He was proceeding on a motorcycle. And by the time the police officer goes to the magistrate, obtains the warrant, do you mean to say the petitioner will stand there? Page 60.
ತದನಂತರ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಶ್ರೀ ಆರೋಪಿಯನ್ನು ಉದ್ದೇಶಿಸಿ ಯಾವುದೇ ನಿಷೇಧಿತ ಮಾದಕ ವಸ್ತುಗಳನ್ನು ವಶದಲ್ಲಿ ಇಟ್ಟುಕೊಳ್ಳುವುದಾಗಲಿ ಕಳ್ಳ ಸಾಗಾಣಿಕೆ ಮತ್ತು ಮಾರಾಟ ಮಾಡುವುದಾಗಲಿ ಕಾನೂನಿನ ಪ್ರಕಾರ ಅಪರಾಧವಾಗಿರುತ್ತದೆ. ನಿಯಮಾನುಸಾರ ನಿಯಮಿಕೆಯಲ್ಲಿ ಅಧಿಕಾರಿ ಅಥವಾ ಹತ್ತಿರದ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಅವರಿಂದ ಅನುಶೋಧನೆ ತಪಾಸಣೆ ಒಳಪಡಿಸಬೇಕಾಗುತ್ತದೆ. ಕಾನೂನಿನ ಪ್ರಕಾರ ಇದನ್ನ ಇದರ ಬಗ್ಗೆ ನಿನ್ನ ಅಭಿಪ್ರಾಯವನ್ನು ತಿಳಿಸಬೇಕೆಂದು ಹೇಳಲಾಗಿ ಅವರುಗಳು ಧರಿಸಿರುವ ಪ್ಯಾಂಟ್ ಶರ್ಟ್ ಯಾವುದೇ ದೇಹದ ಭಾಗದಲ್ಲಿ ನಿಷೇಧಿತ ಮಾದಕ ವಸ್ತುವನ್ನು ಇಟ್ಟುಕೊಂಡಿರುವುದಿಲ್ಲ. ನನ್ನ ಬಳಿ ಇರುವ ಮಾದಕ ವಸ್ತು MDMA, ಕ್ರಿಸ್ಟಲ್, ಮತ್ತು ಗಾಂಜಾ ಎಲ್ಲವೂ ನನಗೆ ಸಂಬಂಧಪಟ್ಟ ವಾಹನದ ವ್ಯಕ್ತಿಯಲ್ಲಿ ಗೆಜೆಟೆಡ್ ಅಧಿಕಾರಿ ಅಥವಾ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಅವರ ಮುಂದೆ ತಪಾಸಣೆಗೆ ಒಳಪಡಿಸುವುದು ಬೇಕಾಗಿಲ್ಲ. Drugs was not found in the possession of the
person, on the person. He was in possession, but it was not on his person. Yes. You are in possession of the vehicle. From where you are apprehended? From the spot. Vehicle was also seized. Then maybe vehicle owner was not in possession of the vehicle then. You are in possession of the vehicle.
Charge sheet has been already filed. There are 11 witnesses.
Yes.
Among the 11 witnesses, we have not made one of the witness, the particular vehicle owner. This is
Yes.
one of the important point that I would like to bring before the Lord.
You can examine him. Yes, you can examine us as your defense witness. That cannot be the ground for granting bail. On merits, it was dismissed earlier. Although that will not make any difference. Then,
In the final case. But his mother is not well. She is undergoing the treatment of chronic disease.
any, ಬರಲ್ಲ ಬಿಡಿ. ತಗೊಳ್ಳಿ. Yes, anything? No. The petitioner being the sole accused is seeking grant of bail. ಅದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. Reasons. Petitioner being sole accused, he was apprehended on 31/12/2023. Since then, he is in judicial custody. The petitioner had approached this court with similar prayer in criminal petition number 2825 of 2024. And the same was came to be dismissed on merit with a order dated 26/6/2024. Even according to the learned counsel for the petitioner, there are no changed circumstances to move this petition. However, it is his contention that the petitioner was not the owner of the motorcycle, which was seized along with the contraband. And therefore, the petitioner is entitled for bail. Whether the petitioner was the owner or not may not be relevant to enlarge the petitioner on bail in the present case. It is the specific contention of the prosecution that the petitioner was found in possession of 24.72 grams of MDMA crystals, 12.62 grams of MDMA ecstasy pills, and 1.54 grams of ganja for the purpose of selling it to the general public. The seized contraband is of commercial quantity, and therefore it is stated that the accused has committed the offense as stated above. On consideration of the materials on record, including the charge sheet, the court has opined, while disposing of criminal petition number 2825 of 2024, that there are no grounds to satisfy myself about the pin conditions mentioned under section 37(1)(b)(2) of NDPS Act. Looking to the nature and seriousness of the offense, the petitioner is not entitled for grant of bail. Since there are no changed circumstances and the matter is still pending for consideration, pending for trial before the trial court, I am of the opinion that there are no reasons to enlarge the petitioner on bail. Accordingly, petition is dismissed. Petition dismissed.
Serial number 14, Vikyat B.
Counsel for the petitioner is absent or representation. Why the person done? Yes. Earlier it was rejected. No, only accused number 12, that is the petitioner is in custody now. Lady na, gents? Lady. She conducted medical termination of pregnancy. No, she has given the medicine to accused number 1. In turn. ಕೊಡಿ. ಇದು ಎಲ್ಲಿ ಅವ್ರು ಇಲ್ಲಲ್ಲ ಬಿಡಿ, ನಿಮ್ಗೆ ಯಾಕೆ ಒಂದ್ ಸ್ವಲ್ಪ ನೋಡಿ. I said there is no parity. Now that, let him come. Counsel for the petitioner is absent, no representation. On the last date of hearing, when counsel for the petitioner had addressed his argument in part, I do not find any reason to adjourn the matter again, however, to offer an opportunity. So finally posted. Next.
Serial number 15, Rajshekar RV.
Earlier it was dismissed. ಸಾಕಲ್ಲ ಮತ್ತೇನು, ಅವರು ಹೊಡೆಯೋದಕ್ಕೆ ನೀವು ಹಿಡ್ಕೊಂಡವ್ರು, ನೀವು ಹಿಡ್ಕೊಳ್ದೇ ಇದ್ರು ಓಡೋಗ್ತಿದ್ರ? ಅದೆಲ್ಲ ಬರಲ್ಲ. Maybe habitual offender, that will not enable you to assault him. Habitual offender anta ಹೊಡೆದು ಬಿಡೋದು. Then that cannot be the justification. One minute it is. Assault with a chopper. The petitioner is accused number? Yes, what is it? CH. Yes. That cannot be the changed circumstance, sir. On merits, it was dismissed. Éನಿದೆ, what is the stage before the trial court?
Is not at all involved in single case. This is the only case. You are in both this and that.
What sheet ಎಲ್ಲಿದೆ? cover. Petitioner being accused number 2 is seeking grant of bail. He was apprehended on 26/3/2024 since then he is in judicial custody. Initially, the petitioner along with accused number 1 had came before this court seeking grant of bail in criminal petition number 4169 of 2024. The same was considered on merits and it was dismissed with an order dated 7th June 2024. Next paragraph. The materials on record disclose that the mother of the injured lodged the first information and the injured and the statement of the injured after he was discharged from the hospital was recorded, where he made specific allegations against accused number 1 and 2. The investigation is completed, charge sheet is filed. It is the contention of the prosecution that accused number the contention of the prosecution that accused number 1 called CW2 and CW2 with an apprehension that he may be assaulted by accused number 1 came with a chopper, came with a machete to threaten accused number 1. Being CW2 with a machete, accused number 1 and 2 have abused him in Hindi language. And there was a galata. When CW2 showed the machete to threaten the accused, both the accused have caught hold of CW2 and the accused number 1 assaulted him with the same machete, causing injuries. As per wound certificate, the injured has sustained cut lacerated wound over left parietal occipital region of skull, measuring 7 by 2.5 by 2.5 centimeter by bone deep. The scan report discloses that the injured sustained comminuted fracture of left parietal bone with acute extradural hemorrhage, which is grievous in nature. He was discharged from the hospital on 28/3/2024. Next, admittedly, the petitioner is not required to be detained in custody for any purpose except to ensure his presence before the trial court. It is not the contention of the prosecution that the petitioner is having any criminal antecedents. Even as per the case made out by the prosecution, the assailant is accused number 1 with the machete, which was snatched from the hands of CW2. The only allegation made against the present petitioner that he was holding this injured while accused number 1 assaulted him. Considering all these facts, the machete used in commission of the offense was seized at the instance of accused number 1. Considering all these facts and circumstances, I am of opinion that detention of the petitioner in custody is yes, allowed subject to conditions.
Past your matter, which one? Serial number 25, DB Patil.
Compromise ಆಗಿದೆ. Yes.
Serial number 25, BB Patil.
26,
25.
25. Counsel for the appellant submits that needful is done, office to verify. If complied with, list for orders. Next,
Serial number 29, Vishwanatha.
26 in I think.
26.
Dismiss I think. Okay.
29, Vishwanatha.
Counsel for the appellant is absent, no representation. The order sheet dated so and so reads as under. The matter is listed for the third time for complaints of office objection. In spite of that, there is no progress in the matter. It is clear that the appellant is not interested in prosecuting it. Appeal is dismissed. Next.
List 2, serial number 3, Mohammed Tahir.
Next.
Serial number 42, Satish K.
Who is Satish? Legal services ಅಂದ್ರೆ ಇಷ್ಟೇನಾ? Fees ತಗೊಳ್ಳಿಕ್ ಮಾತ್ರ. There must be some commitment. With some object that was the facility that was given to the accused. Legal services ನಡೀತದೆ. Then I'll record the same submission and dispose of. Since it is a legal services matter, no need to consider on merits, dismissed. See, once you accept the brief on behalf of legal services, you should be committed to that. Otherwise, you should not. Give a letter stating that I am not interested in that. If you are interested to work pro bono, you can take up the brief. Otherwise, no. ಒಂದ್ ಸ್ವಲ್ಪ ಸರ್ವಿಸ್ ಮಾಡ್ಬೇಕು, ಎಲ್ಲದನ್ನು ದುಡ್ಡಿಗಾಗಿ ಅಳೆಯೋದಲ್ಲ. Being a youngsters, you should avail the opportunity. ಇಲ್ಲ ಅಂದ್ರೆ ಸ್ಟ್ರೈಟ್ ಅವೇ ಸೇರಿ ನಾವು ಪ್ರೋಬೋನ ಮಾಡಲ್ಲ, ದುಡ್ಡು ಕೊಟ್ರೆ ಮಾತ್ರ ನಾವು ಕೆಲಸ ಮಾಡೋದು, ಅದರ್ವೈಸ್ ಮಾಡಲ್ಲ. Whether there is any compulsion to represent legal services, then this should be a lesson to you, both to you as well as the counsel on record. Heard on counsel for the appellant on IA1 of 2022 filed for seeking leave of the court. IA3 of 2022 for the condemnation of delay of 131 days in preparing the appeal. It is noticed that the appellant has availed the services of the counsel appointed by Legal Services Authority. And in turn, the High Court Legal Services Committee appointed the learned counsel for the appellant to represent the appellant. For the reasons stated in so and so, IA so and so is allowed. Delay of 131 days condoned. IA1 of 2022 is allowed, leave is granted. Yes, next. List for admission.
For further hearing, serial number 57, Ritesh Sarbati, Manjunatha AC.
ಇನ್ನೇನಿದೆ? ಅದೊಂದಾಯ್ತು, ಆಮೇಲೆ 59 ಒಂದಿದೆ, ಮತ್ತೆ ಕಾಂಪ್ರಮೈಸ್ ಒಂದಿದೆ ಅಷ್ಟೇ. 59 ಯಾರಿದ್ದಾರೆ?
Serial number 59 Abubakar Shafi, Kavita.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಅದನ್ನು ಮುಗಿಸ್ಬಿಡ್ತೀನಿ. Yes. ಕೊಡಿ ಕೊಡಿ. Notes ಅಂತ ಹೇಳಿ. ಏನು? What is that? First, tell me about the facts of the case. 138 NI. Accused is acquitted. Time ಎಲ್ಲ ಕೊಡಲ್ಲ, ಇದು ಫೈನಲಿ ಆಗಿದೆ. If you want, you can address the argument. Otherwise, I will hear her and proceed. 138 NI Act. Accused. What is this exhibit D1, sir? Between? DW5. What is this agreement? ಸರ್ ರೀಡ್ ಬೇಡಪ್ಪ, ಅದು ಏನು ಅಂತ ಹೇಳಲಿಕ್ಕೆ ಬರೋದಿಲ್ವಾ? ಕೇಳಿದ ಕೂಡಲೇ ಐ ವಿಲ್ ರೀಡ್ ಅಂತ. ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅದು? There is reference to the check, exhibit P1. Accused had issued 6 checks in favor of DW5. What is the evidence of DW5? ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್? They are the witnesses. ಇದರಲ್ಲಿ which is the check? The exhibit P1 check bearing number? Seven four 7428. Okay. Date of check, date of check. Twenty-five. 25 ಅಲ್ಲರಿ 12/5/2004. ನಿಮಗೆ ಡೇಟ್ ಚೆಕ್ ಗೊತ್ತಾಗಲ್ಲ, ಸುಮ್ಮನೆ ಮಧ್ಯ ಮಾತಾಡ್ತೀರಿ. Yes, now what is your contention? Hmm? Hmm. Hmm. Yes. Hmm. Yes. Yes, not necessary. Hmm. Who admitted? Yes, naturally. ಅದೇನು by heart ಮಾಡ್ಕೊಂಡು ಬರ್ತಾರೆ, memory test ಏನದು. It is a cross examination, not a memory test. ಏನಿಲ್ಲ, ಅದೇನಿಲ್ಲ. Exhibit D1 is sufficient. It is much earlier to the date of check. No, check bears the date as 12/5. 12/5/2004. ಇಲ್ಲ, ಮತ್ತೆ ಬೇರೆ ಏನಾದ್ರು? Who filed? Let him prosecute. Let him prosecute. Let him prosecute. We are not concerned about the result of that case. How we are concerned? Acquitted? You are entitled for a conviction. No, sir, sorry. That was not the position of law. ಆಯ್ತು, ಫಾಲ್ಸ್. ಆಯ್ತು, ತಗೊಳ್ಳಿ ತಗೊಳ್ಳಿ. Sir, we are not concerned about that. We are not deciding this appeal depending upon the result of that case. It has no bearing in that. ನಿಮ್ಗೆ ಅರ್ಥ ಆಗ್ತದೆ ನಾನು ಹೇಳ್ತಾ ಇರೋದು? ಮತ್ತೆ ಮತ್ತೆ ಅದನ್ನೇ ಹೇಳ್ಬೇಡಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಕ್ವಿಟ್ ಮಾಡ್ತಾರೋ ಕನ್ವಿಕ್ಟ್ ಮಾಡ್ತಾರೋ ಅನ್ನೋ ಬೇಸಿಸ್ ಮೇಲೆ ಇಲ್ಲಿ ಡಿಸೈಡ್ ಆಗಲ್ಲ. This appeal will be decided on the basis of the materials that are placed before this court. We are not concerned about that. Sorry. ಸರಿ, ಅಲ್ಲಿ ಕನ್ವಿಕ್ಟ್ ಆದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಿ? ಕನ್ವಿಕ್ಟ್ ಆದ್ರೆ ಏನ್ ಮಾಡೋದು? ಹಾ. The complainant in CC 184 of 2012 on the file of the learned senior civil judge and JMFC Sakleshpur is impugning the judgment dated 5th January 2013, acquitting the accused for the offence punishable under section 138 of an act. Brief facts of the case are that the appellant as complainant filed PCR 125 of 2004 against the accused, alleging commission of the offence punishable under section 138 of an act. It is the contention of the complainant before the trial court that he was knowing the accused since for some time. The accused approached him for financial assistance on 25/12/2003. Accordingly, the complainant lent an amount of rupees 1,50,000. The accused issued the check bearing number 007428 for rupees 1,50,000. 2428 dated 12/5/2004 for rupees 1,50,000, promising to arrange for the amount on presentation of the check. When the check was presented for encashment, the same was dishonored as there was insufficient fund in the account of the accused. Legal notice was issued to the accused. In spite of service of notice, there was no reply, nor there was repayment of the check amount. Thereby, the accused has committed the offence punishable under section 138 of the law. Accordingly, he requested the trial court to take cognizance of the offence and to initiate legal action. The trial court took cognizance of the offence and registered CC number so and so. The accused appeared before the trial court and pleaded not guilty. The complainant examined himself as PW1, got marked exhibit P1 to 7. The accused denied all the incriminating materials available on record. In his statement under section 313 of CRPC, got examined DWs 1 to 5, got marked exhibit D1 to 5 in support of his defense. The trial court, after taking into consideration all these materials on record, came to the conclusion that the complainant is not successful in proving the guilt of the accused beyond reasonable doubt. Accordingly, acquitted the accused. Being aggrieved by the same, the complainant is before this court heard so and so. Counsel for the appellant contended that the complainant has made specific allegations that the accused had availed the loan of rupees 1,50,000 and towards discharge of the loan, he had issued the check bearing number 12/5/2004 on the date of availing the loan itself. When the check was presented, the same was dishonored as there was insufficient fund in the account of the accused. In spite of service of notice, the check amount was not paid, and thereby he has committed the offence. He has led the evidence as PW1, got marked the relevant documents. The next paragraph, counsel submitted that the accused do not dispute that the check exhibit P1 belongs to his bank account and it bears his signature. In spite of that, the trial court proceeded to acquit the accused solely on the basis of Exhibit D1, the agreement produced by the accused. This exhibit D1 is a concocted document and same cannot be relied on. Therefore, the trial court committed an error placing reliance on the said document and acquitted and in acquitting the accused. Next paragraph, when counsel submits that the criminal case in PCR number 7 of 06 was filed by the accused against the complainant and DW5 Subramani, alleging commission of the offense under section 468 and 470 of IPC. The same is now registered in CC number 2993 of 2014. Therefore, the present appeal is to be kept pending till disposal of the said criminal case. If the complainant who is the accused in the said case is acquitted by the trial court, it will prove that exhibit D1 is a concocted document. Therefore, he prays for passing appropriate orders. Per contral and counsel for the respondent opposing the petition opposing the appeal submitted by specific contention of the complainant that the accused had availed the loan of rupees 1,25,000 on 25/12/2003. Exhibit D1 is the notarized agreement dated 21/4/2004, where there is reference to the check exhibit D1. It is the specific defense taken by the accused that he had given as many as 6 checks to DW5 while availing the loan, and after repaying the loan, DW5 was required to return the check, but he contended that the checks were misplaced. And therefore, exhibit D1 agreement was executed. DW5 deliberately handed over the bank check with the signature of the accused to the complainant, who in turn misused the same. The evidence of DWs 1 to 4 fully supports the contention, fully supports the defense taken by the accused. Under such circumstances, trial court was right in acquitting the accused. Next paragraph, counsel submitted that pendency of CC number 2993 of 2014 has nothing to do with the present case. And therefore, prays for dismissal of the appeal. Peruse the material point. My answer to the point is the negative for the following reason. It is the specific contention of the complainant that they have lent an amount of rupees 1,50,000 to the accused on 25/12/2003. Denied. The tenor of cross-examination of PW1 discloses that the accused contended that he was not knowing about the complainant. He never borrowed any amount from him, nor he issued Exhibit P1 in favor of the complainant. He pleaded his ignorance regarding the agreement D1, Exhibit D1, got executed by DW5. Referring to the check Exhibit D1, Exhibit P1, and stating that the same is misplaced. The accused examined himself as DW1. In the chief examination, he contends that he is not familiar with the complainant. He never borrowed any amount from the company, from him, nor he had issued Exhibit P1 check in his favor. He states that he never received the legal notice and denied his signature found on Exhibit P6. The accused contended that during 2002, he had availed loan of rupees 2.30 lakhs from one Subramanian, and as security had issued blank checks, 4 blank checks, 6 blank checks. On 21/4/2004, the loan amount was repaid to the Subramanian, but he had not returned the checks on the ground that the same were misplaced. Accordingly, he executed an agreement on the very same day. As per Exhibit D1, in spite of that, he, in collusion with the complainant, misused the check Exhibit P1. Therefore, a complaint is filed against both of them. During cross-examination, witness denied the assertion that he had availed any loan from the complainant and had issued Exhibit P1 towards discharge of legally enforceable debt. He denied the assertion that he concocted Exhibit D1. Nothing has been elicited from the witness to disbelieve his version. Next paragraph. Exhibit D1 is the agreement. DW's 2 to 4 are the witnesses who have signed Exhibit D1. They have supported the case of the accused. DW5 has not supported the case of the accused, and he was treated hostile. DW5 during cross-examination pleaded his ignorance regarding obtaining Exhibit P1 from the accused as his security. It is pertinent to note that he never denied Decide dissociation. Next paragraph. Exhibit D1 is the agreement dated 21/4/2004, entered into between the accused and ex Subramania DW5, where there is reference to availing of the loan by the accused and issuance of 6 blank checks with the signature as security. One such check is exhibit P1, and there is one second. There is a reference to check exhibit P1 in the said agreement dated 21/4/2004. It is pertinent to note that the check exhibit P1 is dated 12/5/2004, which is much after the date of exhibit D1. Prima facie, the defense taken by the accused is probabilized by producing exhibit D1 and examining DW 2 to 4. Once the accused probabilizes his defense, it amounts to reversal of the legal presumption under section 130, 139 and 118 of NI. The burden again shifts on the complainant to prove his capacity to lend and also actual lending of the amount. The complainant has not placed any material to substantiate its contention that he had lent an amount of rupees 1,50,000 to the accused on 25/12/2003. Under such circumstances, it is to be concluded that the complainant is not successful in proving the guilt of the accused beyond reasonable doubt. Hence, the accused is entitled for acquittal. Next paragraph. Counsel for the appellant contended that the accused had filed PCR 7 of 2006 before the trial court against the complainant and DW5 Subramania. The same is now pending in CC number 2993 of 2014. It is stated that the accused alleged that the Subramania and the complainant have misused exhibit P1 and presented for encashment, even though he had not availed any loan from the complainant. According to learned counsel for the complainant, the appeal is to be kept pending till disposal of CC number so and so. But the result of the case in CC number 2993 of 2014 will not have any bearing on the present case. Even if the complainant herein, who is the accused, who is one of the accused in the said case, is acquitted by the trial court, that will not lead to a conclusion that the complainant has proved his contention regarding lending of the amount in favor of the accused. Under such circumstances, I do not find any merit in the submission made by the learned counsel for the appellant that the appeal is to be kept pending till disposal of CC numbers. On merits of the case, I am of the opinion that the accused is entitled for acquittal. I have gone through the impugned judgment, so and suspension. Hence, I answer the above point in the negative and proceed to proceed for life. Appeal is dismissed.
Serial number 57, Venkatesh Sarbati, AC Manjunath.
Yes, ಏನಿದೆ? ಸಿನಾಪ್ಸಿಸ್ ಅಷ್ಟು ದೊಡ್ಡದಿದೆಯಾ?
ಅದರಲ್ಲಿ ಬರೀ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಆಗಿರುತ್ತೆ ಇಲ್ಲ ಜಜ್ಮೆಂಟ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿ ಅದ್ರ ಮುಂದೆ 8 ಪೇಜ್ ಆದ್ರೆ ಎಲ್ಲ ಬರೀ ಜಜ್ಮೆಂಟ್
ಸಿನಾಪ್ಸಿಸ್ ಎಲ್ಲಿದೆ ಇದ್ರಲ್ಲಿ? ಸಿನಾಪ್ಸಿಸ್ ಇಲ್ಲ.
ಫಸ್ಟ್ ಪೇಜ್ itself all the information are there not before I take about this synopsis, brief background of the case. This appeal is not against the judgment of acquittal in relation to not a case of disproportionate assets.
ಆಯ್ತು, ಅದೆಲ್ಲ ಆಯ್ತು. Accused was a storekeeper.
Accused was a storekeeper, usually appointed by the assistant in the year 1968. But then in the year 1992, he promoted first division assistant as storekeeper, and thereafter in December 1992,
Initially, he was appointed as
division assistant.
promoted in
Promoted initially in 1983, thereafter once again in 1992. 31/10/1992, FDA storekeeper. FDA storekeeper. Then 14/12/1991, it is there in the synopsis, designation of the accused earlier. Fourth item. Designation of the accused storekeeper, MOB, Channel Division would be joined in 1968 as FDA and promoted as FDA since 31/10/1992.
14 ಅಲ್ಲ.
14/12/92, he comes to MOB channel. 31/10, he is promoted as FDA storekeeper. Then got based on critical information, but a source report is prepared. In the source report part, in the table you have to fill out. In this table itself, three items are there. As per source report, as per charge sheet, as per trial court.
Yes.
As per source report part, it is found that the accused is found to be having disproportionate asset to the extent of 251%. Charge sheet has the table part in the table itself.
Yes.
Source report is marked as exhibit P1. As per source report number, it is 221% in the disproportionate asset held by the accused. Based on the source report part, the complainant, the informant seeks not the approval under section 70. It is granted to him not as per order dated 3/2/1998 by the SP. Lordships are aware section 70 requires, section 70 of the PCAct requires that for VA cases not an officer not below the rank of USP, unless otherwise authorized, so not the SP authorizes PW1. As per the section 17 order,
PW1, what is his designation?
police inspector.
Yes.
As per exhibit P2, 3/2/1998, section 17 order. Thereafter, he registers FIR.
Yes.
Dated 3/2/1998.
Source report is dated?
Dated 3/1/1998.
Yes.
Of 1998, the 3/2/1998 is the section 17 order. Thereafter, FIR is dated 3/2/1998.
On the same day.
On the same day. Immediately after receiving authorization, he registers the FIR. He marked as exhibit P3. Thereafter, he seeks the investigating officer PW1 to seek a search warrant for the special court would give 3 different search warrants
The search is conducted, order is prepared, thereafter investigation is taken up, thereafter charge sheet is made before the honorable 11th special court. The figures not as per the charge sheet, the lordship will find not in the fourth column of the table. But mainly but there is the here, fourth column of the table as per charge sheet information.
Yes.
All items but there are figures in the brackets also. But it so happened that they are not come to column 17 of the charge sheet.
ಏನಾಗಿದೆ ಅದು ಯಾಕೆ ವೈ ಟು ಡಿಫ್ರೆಂಟ್?
77,000. But throughout it is taken as 17,75,000. Charge B is required as submitted.
Whether 17 lakh is correct or 15 lakh?
Charge sheet appears to 15,77,000. ಅದಕ್ಕೆ bracket ಮಾಡಿ both figures and placing for last. Then expenditure not there is no discrepancy. 5,74,000. Assets plus expenditure not because the charge sheet figure of assets is different, but there is a difference in the total. Then not income there is no issue, 6,14,000. Then not disproportion not there will be two figures, one in bracket not is the mistake figure and the other one is the correct figure. But with this not the investigating officer will file a charge sheet stating that there is disproportion asset of 282.7%. Trial is conducted, appears before the trial court, trial is conducted. There are exhibit PW1 to PW24, prosecution witnesses PW1 to PW24, documents marked exhibit P1 to PW6, material objects nil, defense witness nil, documents marked.
1 minute, 1 minute. As per charge sheet, you have mentioned it as 250.47%. Typographical error.
Yeah. Even assuming the mistaken figure, it is still 250%.
The actual figure is shown in
282.75.
where it is shown.
But it has to be accepted not as per the judgment itself.
Judgment ಅಲ್ಲ ನಿಮ್ಮ ಪ್ರಕಾರ ಎಲ್ಲಿ ಬಂದಿದೆ? ಅಲ್ಲ charge sheet to column number 7 or 17 whatever, there is a mistake according to you. From where you got this 282.7?
Charts are prepared and submitted to the court. From those charts, the figures are taken very well.
Yes.
But I also have to mention in the last year, the FA with the table, the percentage is calculated by charge sheet judgment the percentage.
Yes.
For convenience, I have calculated and but if we come to that percentage, that's my
As per source report, it is 221.55. That is there. Yellow. Okay. Yes. Yes.
Yes. This is the background facts from the last consideration. But the defense witness being nil, document not from the defense being nil.
How many witnesses you have examined? PW4. Last time really did.
Yes.
24.
who are important.
Yes.
they were happening.
It was only I only, PW1.
PW1, PO,
Hmm.
then not PW10, PW11.
Who is 10?
ಯಾರ್ಯಾರು reject, 10 is the submission. ಯಾರ್ಯಾರನ್ನ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಯಾರ್ಯಾರ ಎವಿಡೆನ್ಸ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಅವ್ರು ನನಗೆ to case for my last consideration that those are important. So I am saying those are.
And who are the material witnesses? PW1, 10, 10.
Then got PW10 sub-registrar. You speak in relation to a sale deed. The registration expenses of the sale deed is rejected by the file. So I would
Exhibit.
Exhibit P29.
Then who are the other material witnesses?
Then PW12, you would speak about in the asset exhibit here in PW12. You would speak about the electricity, total electricity expenses, P20. You would speak about total electricity expenses, 16,492. But the trial court could compute and say it does not come to 16,492, it comes to only 16,000. So this witness is not proper, the document is not proper, entire amount is rejected. So I will take a lot short,
ಮತ್ತೆ any other witness?
Valuation of house construction.
Yaru, who is he? Valuer.
Valuer. He is the assistant engineer in the technical audit cell of the Karnataka government. He is a valuer. He speaks about valuation of the house. Exhibit P21 is in the report.
Exhibit
P21 is in the report. He arrives at a valuation of 11,51,777. Trial court says the valuation is not properly done and rejects the entire. ಮನೆ ಇದೆ, ಮನೆ ಕಟ್ಟಿರೋದು ಹೋಗ್ತಾರೆ. 11,71,000 or 51,000 ಅಂತ ಹೇಳಿದ್ರು. Trial court finds fault in the manner in which it is done.
Yes.
Reject the entire.
Then
PW 14, 15, 16. These are the landlords. Where the accused was residing on various dates and time, place. PW 14, 15, 16. Our house rent interest not ಹೇಳ್ತಾರೆ. ನಮ್ಮ ಪ್ರಕಾರ ಟೋಟಲ್ IO ಪ್ರಕಾರ ಟೋಟಲ್ 74,000 ರೆಂಟ್ ಪೇ ಮಾಡಿರ್ತಾರೆ. ಮೂರು ಜನ ಹೇಳೋ ಕಂಪ್ಯೂಟೇಷನ್ 33,000 ಬರುತ್ತೆ, 40,000 ಡಿಫರೆನ್ಸ್ ಇದೆ. ಸೊ ಎಂಟೈರ್ ಅಮೌಂಟ್ ಇದೆ. Then joint director statistics are PW18. Exhibit P19 is his report. For the check period one, there is an expenditure.
exhibit P.
PW18, exhibit P19.
What is the report?
He says not there is a family expenditure of 2,21,000 over a period of 30 years. That is rejected by the trial court. Saying it is not properly done. Entire amount is rejected.
What is the amount estimated?
2,12,980 for a period of 30 years. And he would also, in the cross-examination, speak about agricultural land belonging to the accused. That is not taken, accepted by the trial court and held against the prosecution to say that the agricultural income is not. These according to, of course, all of them, but these are the witnesses which I guess.
The witness spoke about agricultural income.
Agricultural land he speaks about. Then he also speaks about the fact that since they had agricultural land, our expenditure is ಸ್ವಲ್ಪ ಕಡಿಮೆ ಮಾಡ್ತಾರೆ. ತರಕಾರಿ ಅವರ
Yes.
So to that extent, so the entire amount is rejected by the. But these are the important assets. So far as I cannot to my last case.
Who are the other witnesses?
The other witnesses are the PW-24 in the IO of the charge sheet. PW-1 not conducted major part of the investigation. The last few parts not PW-24 conducted and he submitted the charge sheet. Then not there is PW-2, 3, 4 who are not the punch witnesses for the mother. PW11 is the RTO, the amount is not disputed. PW9 is Sure, granite seller, amount is not disputed. PW8 is the employer of the son of the accused. Salary of son of the accused is not disputed. PW8. PC Nanjudaya, not PW7. Lender to the accused, not in dispute. PW6 is Kumar. Lender to accused, not in dispute. So our
Lenders are PW6 and?
PW6 and 7. They say we are not ready.
They are not supported.
They are not. If they are supported, if they are rent, there is more income.
They supported the case.
Anyway, if my last point is what.
Like a negative evidence, why you have like statement ಅಲ್ಲಿ.
PW ಇದು ಶೆಡ್ಯೂಲ್ ಮಾಡ್ಬಿಟ್ಟು ಕೊಟ್ಟಾಗ ಅದಕ್ಕೋಸ್ಕರ ನಾವು ಅವ್ರನ್ನ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕರ್ಕೊಂಡು ಬರಬೇಕು. PW 1920 would give salary details of the accused. That is also not.
ಇದೆಲ್ಲ ಸಿನಾಪ್ಸಿಸ್ ನಲ್ಲಿ ಬೇಕು ಅಂತ ನಾನು ಹೇಳಿದ್ ನಿಮ್ಗೆ. ಇದೆಲ್ಲ ನಾನು ಬರ್ಕೋಬೇಕು ಇವಾಗ. PW6, 7 ಆಯ್ತು. ದೆನ್ PW ಆಯ್ತು, ಅದೆಲ್ಲ ಆಯ್ತು. 5 ಆಯ್ತು, 11 ಆಯ್ತು, 9, 8, 6, 7. ಅದಾಯ್ತು. ದೆನ್ 2, 4, 5, 6, 7, 8, 9, 10, 11, 12.
12 is the KEB officer. Then
ಅದಾಯ್ತು.
13 is the house valuation person. 14, 15, 16 are the landlords.
ಆಯ್ತು.
17 is the gas cylinder agent. The amount is not disclosed. 18 is the expenditure value. Joint director strategy. 18. 19 is the 19 again salary details. 19 and 20. They will speak about the salary details. 21 is the tenant of the accused. 22 will speak about the documents in relation to the contractor license of the son of the accused. 22. Then Saab in fact, that is also not. 23 is the telephone communication person. Telephone deposit forget that is also not. 24 is the IO person. With this background, may I request not to for a moment take section 13(1)(e). After seen it several times, my submission not I will request to look at section 13(1)(e) in the manner in which the Honorable Supreme Court has interpreted section 13(1)(e). How not a disproportionate asset case trial is required to defendant. Very hard. 13(1)(e) before the court date. That book also may have
Yes.
13(1)(e).
Yes.
13(1)(e). The public servant is to commit the offense of criminal misconduct if he or any person on his behalf is in possession or has at any time during the period of his office be in possession for which the public servant cannot satisfactorily account of pecuniary resources of or property disproportionate to his known sources of income.
Yes.
But I was here for a minute and discussion about clause E. Clause E requires not for the purpose of the ingredients of this offense are that he must either possess the property himself or on behalf of someone.
Yes.
The computation can be about the accused or on his behalf someone else, like the family member. Then what? That is during the period of his office. Public servant cannot satisfactorily account.
Yes.
Satisfactorily account of the keywords of pecuniary resources or property disproportionate to this known sources of income. So, what the keywords, key phrases here, in my opinion, satisfactory account, known source of income.
Yes.
So, he has to satisfactorily account.
Yes.
He has to disclose his known source of income.
Yes.
That is the government of 13 Now, but the explanation, again, this explanation plays a very, very important role, not in understanding what is the satisfactory account, what is not the. For the purpose of this section, known source of income means income received from the lawful source, and such receipt has been intimated in accordance with the provisions of the law, rules, or orders for the timing applicable to the public servant.
Yes.
So, but as per this explanation, I think very salary bantu, samla bantu, India, agricultural family income bantu, which is received by me, a small amount or a bigger amount, that is not sufficient. It has to be disclosed.
Yes.
And declared in a case to an authority as required in law. For example, for an income tax return. Many of us file income tax return, include government service, not file income tax return. If not, this person has a salary income, rental income, agricultural income, that is not sufficient if it comes through proper banking channels. It is required of him to submit income tax return and disclose and declare it in the income tax. Only then it becomes a lawful source.
Yes.
If he is a government servant, in terms of this ACS conduct rule, he is required to file annual property returns, and APR is required to be filed every year by every government servant. If it is disclosed there, only then it becomes a lawful source. So, not read this explanation.
Yes, yes. Satisfied, I got to that.
I leave it. So, because not I'm trying to submit, make this submission, because three of those judgments you can rely upon would say to speak about how known source of income and satisfactory account has to be. It's not just sufficient if I can disclose if it is received under in normal banking channels. He has to disclose it to the income tax authority, he has to disclose it to the APR. With this background, I also submitted to the last consideration that the defense has not read any evidence.
Yes.
But with the reading of 31E, satisfactory account and a known source of income.
Yes.
He had to satisfactory account. Once we are making space before the court by the investigation officer, the accounting of satisfactory accounting is the responsibility, the obligation, is the burden on the appeal is what I will take the demonstration. I'm not coming to the various materials, including what evidence of PW1. Before that, may I take part to the judgment itself. How what was the contention there and how the special judge treated each of those contentions.
Hmm?
The accused had retired when the charge sheet was submitted.
Yes.
So the trial court not felt that cognizance for the purpose of taking cognizance action is not required. And that also was not disputed by the defense at the time of trial. Because the paragraph 13 of the judgment regarding sanction, the trial court proposed to conclude the sanction is not required because he had already retired.
Yes. Yes.
Then an important pretension was taken by the accused, by the defense before the trial court, that the charge framed was a defective charge. There are two charges, twice not charges are taken.
Thrice also. 3 times.
I see.
Alva? Twice. Sir. Yes.
Once in October, once in 13th April 2010. And one more time on 21st October 2011.
Yes.
That is not discussed as the paragraph 14 to 18 of the bill.
ಇದೊಂದು 14th August 2007 ಇದೆಯಲ್ಲ. ಸೈನ್ ಮಾಡಿಲ್ಲ ಹಾಗೆ ಇದೆ. ಸೈನ್ ಮಾಡಿಲ್ಲ. ಡ್ರಾಫ್ಟ್ ಇಸ್ ದೇರ್. ಎಸ್.
Relying on 15 of the CR. Paragraph 14 to 18, the discussion about effective charge, the contention about effective charge. And paragraph 2, relying on section 215 of the CR, that is present to come to conclusion that there is no legal effect because the accused has sufficient opportunity. The accused was aware of what amounts were there in the charge sheet, in the all the documents. So that para 18, the typographical error is so the contention is these are one and sanction and defective are technical contention part is rejected by the learned as then not next 4 contentions. That is not. One more technical contention is that PW1 is the informant. He prepared the source report. He is the IO who registered the FIR based on the authorization order.
Yes.
Then he conducted investigation. Contention was taken with the possibility of bias. So that contention was also rejected by the trial court, paragraph 19 to 23. We are rejected by the trial court. The next thing are
Para number you are referring to?
For regarding PW1 being the informant and IO, para 90 to 20. Next 3 conditions. 1, valuation of assets, para 26 and 27. He accepted by the trial court. Most of it. Then I would say contention number 2, valuation of expenditure, 28, 29.
Yes.
Valuation of income, 30 to 33. These 3 conditions, valuation of income, 30 to 33.
Yes.
These 3 contentions are held in favor of the accused and against the prosecution.
3 ಅಂದ್ರೆ valuation of expenditure, valuation of income. Your the contention taken by the prosecution was not accepted. Yes.
The two was in possession of assets worth 17,75,480. As on 4/12/2023. You will also see that from the synopsis, 70,75,000. This is the figure, 70,75,000. The expenses incurred during that period, 5,74,000, the total income 6,40,000. So it is again that the accused was in possession of disproportionate property disproportionate to most of the tune of 30 lakhs. As I have already discussed, my narrative the argument was that the defense has seriously disputed the valuation of the property made by the prosecutor. Defense has also raised serious objections with regard to the expenses shown by the prosecutor. He has also contended that the investigation defense has not taken income of the accused property. With this, I will now proceed to examine the oral and document defense with regard to the charge narrative. Again, here, for the purpose of the list of assets are taken by the investigating agency as part B. As per the statement, the accused was in possession of assets mentioned there to the tune of ₹17,500 as of 3/2/1998. The prosecution having taken such a stand as to prove the same, to put it in other words, the burden is on the prosecution to establish as to what were the basis to arrive at the above said figure. As per the prosecution case, this figure is arrived on the basis of the report given by the concern and also on the basis of the inventory of articles prepared in the other case that itself and other documents printed in the. But the heavy burden is on the prosecution to show that chart B represents the assets in possession of the accused was properly prepared and it reflects true and correct position of the assets at the present time. And rather for a moment, the premises on which the special judge would proceed to consider the materials in the case is that the heavy burden in the prosecution. Now that is my submission as per the law and section 30 along with the explanation. The burden is on the accused. Of course, not initial burden, but this is the slight change, slight shift from the other cases, other offences, any other IPC offence or any other not even CC Act offence. This is a different kind of offence, where not the burden is not entirely on the prosecutor. The burden is on the accused. Para 26. As the accused has raised doubts, as the accused has raised serious objections to the valuation made by the investigating agency, as the accused has raised serious objections to the valuation made by the investigating agency, also the valuation made at the time of the correctness and authenticity of the valuation was in the case of the chart B is to be discussed. So that if the chart B is the list of assets, one item number 1 to 30, total not is about 30 lakhs 75,000. Is taken to be not true. About 2 lakh 5,000 is taken to be true. Of each of the items, and just not take not to the each of the items. Item number 1 is not to the residential site. This plot is not in dispute. The trial court says this site is true. This value is true. Even though it is in the name of the son of the accused. And the reason for accepting this valuation is that the accused is accused and his family members are residing in this house, and the accused has constructed the house on this site, which is the next item. Next item, 11,51,000 is the RO Khata number 20 name only. And also, can you see the brackets? RO this is that 11,51,730. The same thing is spoken to not by PW30. As per the report in Exhibit P21, the trial court rejects this entire amount of 11,51,000. Similarly, next item is
Exhibit P21.
P21. Item number 2, PW30, Exhibit P21. Then item number 3 is admitted to be true, that is Hero Honda motorbike. Then item number 4, 5, 6, 7, 8. 5 items. Item number 4 is gold ornaments, 48,600.
What about item number 3, Hero Honda?
Hero Honda motorbike, admitted. No problem.
Then
4, 5, 6, 7, 8, 5 items. 4 not is the gold ornaments for 48,600. File for sale not true. Silver ornament 2,550. Serial number 5 not true. Electronic items 73,250 not true. Household articles 67,000 not true. Electrical items, item number 8, electrical items 31,000 not true.
they were noted in the Maser.
This valuation, ಆಧಾರದಲ್ಲಿ ಏನು ಕೇಳ್ತಾರೆ ಕ್ಲಾಸಿನ ನೀವು ಇದಕ್ಕೆ ಮಾದರಿ ಹೋದಾಗ ಇದಕ್ಕೆ ಸರ್ಚ್ ಕೊಡೋದ್ರೆ ಯಾರು ಈ ಟೆಕ್ನಿಕಲ್ ವಿಟ್ನೆಸ್
Yes.
valuation about that. He says no. Do you have any technical knowledge about gold ornament, silver ornament? Yes, no. But the availability of those ornaments are not there. Availability of those electronic items are not there. Only this valuation is then not. So then item number 9, bank balance rule. Item number 10, electricity deposit rule. Item number 11, gas deposit, rule. Item number 12, telephone deposit rule. Item number 13, GPF and EGIS balance 71,000 true. But what is not true is item number 2, 4, 5, 6, 7, 8.
Yes.
Two, 4, 5, 6, 7, 8 not true. Not true, not to be ignored. Not accepted. Others for items number 4, 5, 6, 7, 8. Already they will be 4, 5, 2,
Exhibit P9.
P9.
PW.
PW1.
Who are the Maser witnesses? Maser witnesses have also spoken. All the witnesses were supported.
Supported.
PW22.
But how would these items are rejected after this paragraph 26.1234? But regarding item number, serial number 1, that is the site. Site, though not the trial court says is true, the reading about this is not necessary for the next item, that is construction of it.
Yes.
I'll read one at page 20, but small Roman one. This is the site bearing number 24 situated at Prosecution has faced a copy of saying not examining legal return this is evidence he has stated that he has issued a legal admittedly this document is the name of Ravi Kumar, son of the accused. Though this document is nothing for rejected, it is not a certificate copy. The fact that the site stands in the name of Ravi Kumar is not included. Surprisingly, the accused has constructed a extensive road on this site. It is not included. It is not the case of the accused that on date exhibit 329, that is 12/1/95, his son had independent income and he had purchased sale of application. For all these reasons, I have declared the property both the accused and purchased sale from authorized only. Not saying. Though starting the name of the son, the learned special judge would say it is the property of the accused. Then item small number 2, the construction property respective other land over 1245. Over to the PW13, exhibit 321. It is a residential constructing in site number 1. The value of this property is shown as 11 rupees 11 and 51. Prosecution and sale exhibit 321. The evaluation report also the evidence of PW13 before this one. PW13, Sriram Reddy, the assistant engineer, was evaluated building and care report. And because before this court, after the receipt of he evaluated the house and gave report as per as to be seen from 329, he inspected on 15/7/98 and evaluated the same as per the schedule of grades existing in the 95, 96, 97. The cost of right is rupees 11 lakhs. Accused is seriously included in evaluation. According to PW13 has not evaluated building stage-wise, and he has not collected certificate of commitment. The building plan and also the market value of the construction material during the year 1996 and 1987. He has also not exposed the base of the building before evaluating this. Admittedly, he has followed through. He has not collected information regard to at whose supervision the building was constructed. If the building was constructed with the supervision of the owner, 10% deduction has been given in the evaluation by evaluating the building. As PW13 has not collected any information regard to this fact, the evaluation made is not proper and hence he prays for evaluation. There appears to be some force in the argument of the accused. This is because in the cross-examination of PW13, he has admitted that he has not secured the building plan. This would mean that he has inspected the property without having a sanction plan. Sanction plan is a document which not only provides design for the construction of the building, but also approximate period of construction. It is also admitted during his further cross-examination that he has not obtained commencement plan completion certificate and he has not evaluated the building statewide. Further, PW13 has admitted that he has not examined what type of steel was used to construct the building. Surprisingly, he has admitted that he has not obtained the market value of construction. Materials were in expired at 696. It is an exhibit that the cost of building was worked out based on the scheduled rates of PWD and use circuit. But that what was the scheduled rates of PWD of period 95-96? Not made available. PW1 has admitted during cross-examination and PW1 son of the accused with the civil. It is PW1 has admitted during cross-examination that Sri Ravi Kumar, son of accused with the civil. It is specific case of the accused that the house was constructed at the personal supervision of his family member. It is an established fact that if the building is constructed at personal supervision, 10% deduction has to be given by evaluating the cost of construction. This fact has also been admitted by PWD at 30 at para 5 of the proceeding. It is evidence of PWD that he has not collected information on whose supervision was constructed. It is not the case of the prosecution that the building was constructed under the supervision of the contractor. It's certainly the case because the 13 should have given 10% deduction of the evaluation of the cost of the building. For the reason question not given. For all these reasons, this court is of the respect view that the prosecution has not established through the evidence of PW 13 and exhibit that the cost of building was under this circumstance. I am of the that the prosecution has not made any legally acceptable evidence to show that valuation of item number 1 of the at level is properly made. This is the finding what is in relation to one item. In relation to all the items which are rejected, this is the similar finding. An amount is given to us. In these kind of again, not these are all arithmetic decision in the compute mark of the facts and circumstances. But only not somebody who has personal knowledge, only who has actually done the work can not say with precision, I have spent X amount, I have spent Y amount, I gave Z amount to this person, A amount to this person. Other now, a report which is given by an independent person, qualified person, is punched with the holes.
Yes.
So, what is the alternate value? If plot 1151 is not there, it is not the case of FU, then the house itself is not constructed. The house is there. In the previous paragraph, the sentence comes to the conclusion that accused has constructed the house. House is there. Entire amount not have been obliterated. If 10% deduction was to be given, minus 1151 and minus ಮಾಡಿ ಅದನ್ನ ನಾನು ಚಾರ್ಟ್ ಮಾಡ್ತೇವೆ. So but today it is not 1151, it is 5 lakhs, it is 3 lakhs, it is 10 lakhs, or it is not there at all. The accused should have entered mention, or he should have got led evidence. Then there is admission of the fact. Yes, the construction is made by the accused.
Yes.
26.3 this is the year on the way. Last claim next day. Therefore, the valuation payment prosecuting agency is accepted and accordingly. 26.4 regarding item at serial number 48. This is the gold ornament, silver ornament, electronic items, household items, and electrical items. 48. 26.4.
Yes.
These are in respect of gold and silver ornament, articles, electronic gadgets, household items, and found in the house of the time of trade.
Yes.
It is independent that these items are not properly valued in the business trade. The value is exaggerated and repeated in the process and it will get taken by the property rather than date of trade. All the properties are purchased subscribed to the date of trade and gold and silver are only $2 and the rest of the other prices are not some force because though the prosecution has conducted every time the gold is by name, we value of present, prosecution has neither stated in a business nor examined before the court. At para 12, the prosecutor and need to he has knowledge of the assess the value of the articles named in directed in Article 39. Therefore, neither the investigating officer nor the assessors to the mother having as well as to evaluate these items. So, what were the basis to the value of each item? Serial number 4. This is a serious information. So, what is reflected that the regard to valuation of 438 on the house therefore evaluation these items are accepted. This has previously affected the calculation made in Article 39 as the assets for the this is the finding. So, not same finding as earlier. In relation to construction, it is same finding that the valuation is not done strong. But the items being there is not used. We would also know the corrected. Condition for amount group, the rate is not
Why? Why?
But it is not disputed that these items are there. Gold items, gold are how you it was if it was gifted by the father-in-law, but the personal knowledge is of the accused. Either he has to give evidence, happen to witness or give evidence, or his wife or there are two wives.
These items were never disclosed in APR.
No, this is also not. APR file ಮಾಡಿ.
File ಮಾಡೇ
4 years ಮಾಡಿದ್ದಾರೆ ಅಂತ ಒಂದು ಕಡೆ information ಇದೆ. But that also copy is not posted. It has come in the evidence of PW, 4 years APR is there. 4 years APR is there, the information went through. When I communicated to accused to give a copy, he would not give. When I communicated to employer, I have not received. Out of 30 years.
Yes.
Then 26.5 I'll speak for bank balance is not disputed. 26.6 I'll speak. That is the electricity deposit. And not disputed. 26.7 I'll speak not disputed. 26.8 I'll speak not disputed. The not disputed are the last sentence equalized. Therefore, the prosecution has taken this amount rightly towards the asset of the accused. Therefore, the contention of prosecution that accused has deposited this amount is accepted. Equalized last. Then not 26.9. Item number 30 of the asset. That is about the DPF and EGIS balance. That's case not disputed. And para 28. This is about the assets. So not about the assets. My reference submission is item number 2, 4 to 8 of the chart B table is rejected. In toto. In toto completely rejected. Item number 2, 4 to 8.
Yes.
So that in my synopsis, you have to proceed. In my synopsis, the last column. And again, this is not just one incident which has taken place and one offense which has taken place and it is discussed in the it is not so. It is not again a churning, a discussion has to take place at various levels. Not there is an initially a source report in there. The figures are in one set. Thereafter, not charge sheet. Now information came to your portal.
Yes.
But the churning takes place not at the final stage before the trial court. Trial court should say 100 rupees, 50 rupees, 100 rupees, 100. That trial court has not said in any in relation to any item. So that I consciously and with great respect and consciously not following what I said, not available. The trial court has not given its own figure to any of it. They have just the trial court has just rejected. So that in relation to the assets, the trial court should have said 2, 4 to 8 evaluation correctly last. None ಪ್ರಕಾರ evaluation ಅಥವಾ ಅದು ಹೇಳೋದಕ್ಕೆ defense should have stepped into the witness box and said that this valuation is incorrect, this is evaluation. For example, the trial court has come very close to that house construction finding. House construction trial court says accused has constructed the house, no doubt. Site is purchased in 95, no doubt. Not in dispute.
Yes.
1151 ನಲ್ಲಿ 10% supervision ಕೊಡಬೇಕಾಯ್ತು. ಇನ್ನೊಂದು 20% discount total 30% discount on 7 lakh ರೂಪಾಯಿ it seems reasonable for construction of the house of this size ಅಂತ ಹೇಳಿ ಒಂದು finding ಕೊಟ್ಟಿದ್ದೆ. It would have been a different aspect altogether.
Yes.
This is the confused part about the assets. Now, 2 more items are there. One is the expenditure, the other is the income. Expenditure not is the
How much time you going to?
It is close to one.
Next expenses.
Expenditure. Could I speak to that because same my submissions are the same. Then I can go to the deposition. The expenditure, what I submitted about assets. Expenditure, what is rejected, I'll see them and then that next page table is there. Till number 1, 2, 4, 5, 8.
Para number?
But para 28, internal page 30 and 31 of the document.
28.
Para 28.
Hmm.
The table not at next page. You see the
Yes.
same table from chart D. Not in this item 1, 2, 4, 5, 8. 1, 2, 4, 5, 8. 10, 12, 13, 14 are rejected.
1, 2.
1, 2, 4, 5, 8.
Hmm.
10, 12, 13, 14. 1, 2, 4, 5, 8. 10, 12, 13, 14 are rejected. On not just more or less, but on the same ground. That the valuation is not proper. But relating to income, only 2 items are there.
Then
Income not at the internal page 42. Start with para 30. Only 2 items are there. One is rejected, 2 is accepted. And one more is added, though not in this table here. The agricultural income is the file code would say agricultural income add on in the market. But reasoning of the direct there.
yes.
Reasoning of the direct is but on the face of it unreasonable, I would say.
Hmm.
In some option. So mainly see on this table, income table. ಆರೋಪ ಪ್ರವಾಸ ಅವಧಿಯಲ್ಲಿ ಪಡೆದಿರುವ ಸಮಗ್ರ ವೇತನ 4,1958 3,299 5,89,500.
That was accepted.
That is not accepted. The entire amount is said to be not true.
Hmm.
But if the income itself is not there, it is knocked off from the table. That is why I would not cautiously say that if the trial court would say that this is not accepted, someone should say, someone should tell the trial court that this is not correct, this is the correct figure. That someone is the accused not under section 31B and the explanation.
Yes.
Trial court would knock out the entire cross value.
Hmm.
You add ಮಾಡಬೇಕು ಅಂತ ಈ ಕೇಸಲ್ಲಿ there should have been proved or submitted or something should have been done. Trial court does not find it necessary.
Hmm.
So, but again here also, about agricultural income, trial court says there is some reference to the agricultural property being there within the family. He has 1/3 share, so that agricultural income of 1 lakh agricultural, 1/3, 45,000 should have been taken. 45,000 is not taken. Right. Fine. But again, ultimately, explanation is completely lost sight by the special thing. That agricultural income should have been declared somewhere. Should have been declared at least to the IO. None of it is done. Some material the IO receives. But the IO is not in a position to accept that material because it is not disclosed either in the income tax returns or to the APR.
Hmm.
So IO does not take material risk. The learned to find fault. It is a complete misunderstanding about 13 money and
Yes. Some other Saturday. Hmm? Saturday. Saturday. Hmm? Saturday, leisurely I could have heard. Hmm? Inconvenience ellarigu, except for the court. Friday. Hmm. Friday. No, sir, sorry. Friday you are not in station, Saturday you are not in station, Sunday I will not sit. Then other day we will be busy with other matters. ಎಲ್ಲಾದ್ರೂ ಹೋಗಿ, but not at the cost of this. No. ನಾಳೆ. Tomorrow. But both of you, even immediately after hearing him, I will come back to you. You should be ready. ಆಮೇಲೆ ಅವ್ರನ್ನ ಕೇಳಾದ್ಮೇಲೆ I will pray for time ಅಂದ್ರೆ I will proceed to dictate. Be careful. ಏನು? ಸಾಧ್ಯನೇ ಇಲ್ಲ. I could pursue. ನಿಮ್ಮ ಮುಖ ನೋಡಿ ನಂಗೆ ಗೊತ್ತಾಯ್ತು ನಿಮ್ಮ ಸಬ್ಮಿಷನ್ ಏನಿರ್ಬೋದು ಅಂತ. I will not grant. You have heard him. Okay. We are having the synopsis with you. You should go on tomorrow. Next. Regular. No, sir, sorry. Sir, parted matter, you should understand the difficulty of the court. Can you remember all these facts? Next week? Can you remember? Humanly impossible. That is why law mandates hearing day-to-day basis. We are also human beings. You may be having one matter, but I have to decide several matters. We are having our own difficulties. You should understand that and assist the court. Please cooperate with the court tomorrow. No, sir, sorry. Next, tomorrow.
Serial number 3, Mohammed Taib.
No, ಯಾವುದು serial number?
Serial number 3, serial number 3.
Petition. Who is present before the court? Muzammil Ahmad. He is the husband. Who is she? Momina. What about the other petitioners? Who is representing them? Yenide? CC number 9046 of 2019.
Petition number 1 registered against the respondent. Same is withdrawn on 15th of this. Already withdrawn.
Yes, Raji Agida.
Yes.
ರಾಜಿ ಆಗಿದೆ. ಇದನ್ನು ತೆಗೆದಾಕೋದಕ್ಕೆ ಏನೋ objections ಇಲ್ಲ ತಗೊಳ್ಳಿ. Petition number 1, so and so, and respondent,
Sole respondent, your lordship.
respondent, so and so, are present before the court, and they are identified by their respective counsel. Then counsel for the petitioner and petitioners and respondent submit in unison that the dispute between the parties is amicably settled. They have filed the compromise affidavit jointly sworn by petition number 1 and respondent. The compromise affidavit reads as under. Joint compromise affidavit reads as under. Petition number 1 for himself and on behalf of petition numbers 2 to 5, who are his parents and siblings, admit the contents of the compromise affidavit. Respondent also admits the contents of the affidavit and submits that she has no objection to quash the criminal proceedings initiated against the petitioners. Satisfied with this answer, compromise affidavit is accepted in view of the above, so and so allowed. Quash. Yes, they have to sign the order sheet, you have to identify them.
Much obliged.